You inform the other side.
If possible.
This is with regard to that Azara. Pending.
My lord, I pray adjournment for item number 5.
Yes, madam, why?
The engaged counsel is sick. Not in a position to attend the court today.
Engage counsel, Mr.
A. Shahad. Advocate A. Shahad.
A prayer is made on behalf of Mr. A. Shahad, learned counsel for the petitioner for an adjournment in the matter on the ground of personal inconvenience. On the ground that he is indisposed. Full stop. Registry to list this matter again Thursday?
Okay, Thursday.
On Thursday.
Highly obliged, my lord.
Sorry. Seventeenth. Only thing we got to see here is, see, that 2003 to 2007, 17, 6 or 7, whatever it is. In between the 2006, the 6 CPC came. Then 2016, the 7 CPC came. Now you stop at 2003 and that pay you have taken and fixed it when he resumed service. That's the only error. You rectified that, he gets everything. Whatever other things, 50%, 60, we are not touching. But this has to be rectified. On the prayer of Mr. S.S. Roy, learned CGC, appearing for the respondents, not being objected to by, for an adjournment in the matter, same not being objected to by the learned counsel for the petitioner. A registry to list this matter again on 9/12/2025. 9/12. You examine that aspect.
Please, Lordship, I beg to mention item number 4. Can it? I'm going through the file, man. I have also
We'll help you.
some records are there. I have to go through, man, because I'm also stuck in some criminal case by amicus matter, man. Both.
On the prayer of Mr. D. Gugoi, learned counsel for the petitioner, registry to list this matter again on 25/11/2025.
I had another prayer, man, regarding item number 12. Some instructions are sought for, man. A week.
Why?
Lordship had asked for the breakup. So they are preparing, man. I had just mailed them. Yes, it is taking some time, just a week, man.
On the prayer of Mr. D. Gugoi, learned standing counsel for his department, registry to list this matter again on 26/11/2025. Mr. Gugoi shall on the next date of listing invariably place on record his instructions with regard to the manner in which the pay of the petitioner herein was so fixed. We don't know. We'll see. This is where you are for the respondent. Only the question is maintainability.
Item number 25 and 20. I am appearing on behalf of.
Sorry,
Sir, my
rejected.
lord.
There was a prayer made by the learned counsel. There was a prayer made by the learned counsel. We are taking it up after the top of the list matters. You make your submission.
My lord,
We'll consider. You come. That day he said there is a senior counsel engaged. So if the senior counsel is arguing, we'll see. Otherwise, the government had made a mention. We'll not pass any orders now. When the matter is taken up, renew your prayer. Yes, Mr. Chaudhary, what are you waiting for? Yeah. Oh, that matter. That matter. Yeah. Do number today.
Councillor খবর দি
Somebody inform the standing counsel PWD.
from Dipankar Nath. doesn't look nice also, item matter of 12. Lord, only short point is whether we should get the seniority or not. Lordship should kindly have the
Introduce.
rules. Lordship knows all this everything very well. এই কিতাপখন আছেনে?
Yes.
Lord will kindly have a rule by 11(4)(c). Notwithstanding,
এইটো নহয়।
page 9.
এনেকে আৰু এটা আছে।
Lordship can take this, Miller. Notwithstanding, the losses got it, Miller. 11(4)(c). Notwithstanding anything contained herein before in this subject to suitability, a subordinate engineer grade 1 of the Assam on his acquiring the academic qualification for direct recruitment assistant engineer shall be promoted as provided in Rule 14. This is very important, Milord. Against the next available vacancy in the cadre. And such promotion shall be treated as direct recruitment, the cadre of assistant engineer. Now, my lord, there is a dichotomy also in the rule, in the sense that this promotion would be treated as a direct recruitment. And we are seeking, my lord, seniority over the direct recruits because our case is, since it is a promotion, therefore, in terms of Rule 22, now please come to, my lord, Rule 22(3). Seniority.
22.
22(3).
Hmm.
A member appointed by promotion against the vacancy occurring in a year shall be senior to the member appointed by direct recruitment of that. But if we read this Rule 11(4)(c)
Hmm.
harmoniously with 22(3), the fact that we are promotees against the next available vacancy, even if we construe it to be direct recruitment, my lord, will catch up. Now, admittedly, we were recruited in the same year, whether by way of a promotion or by direct recruitment. Now, our direct recruitment would be to the against the next available vacancy. So, now the factual position is, if your lordship would kindly come to paragraph 15, my lord, the relevant dates are mentioned, my lord. At
Para
page 9, para 15. Before that, lordship may kindly note, on 18/9/23, we were promoted. 2003, sorry. At page number 27 and 28, Miller.
Some error in the second line,
Yeah.
para 15, February 2009.
I'm sorry, Miller.
Could be 2003.
Yes. 2003, yes. With 3, Miller. Now,
When
please
did you
have-
clear, you cleared the examination in the year 2003 itself.
And my lord, that too by taking permission from Assam Engineering College. Because there are some who acquires this degree from some by
Private or something.
Ah,
That is not the
that is
issue
not
here.
the case, yes. That the petitioner states that although the petitioner had submitted their application for promotion in February and the same were forwarded by letter dated 22 after a long delay of about 7 months, 12, the respondent number 2 issued the order dated 89/20. During this period of 7 months, 12 days, the respondents have appointed at least 180 assistant engineer. That is respondent number 5 to respondent number 184. Resultantly, due to the lapses on the part of the respondent, so all the aforementioned direct recruits appointed during the period from February to 2003 to September. Therefore, without prejudice to any other contention raised, petitioner state that seniority position of the petitioner should be placed at least above those direct recruits appointed February 2003 to September 2003. So
And
our
they are
right
private
is because to
respondents
the
here.
next available vacancy, there were vacancies. Now, even if we miss the bus that way, my lord, since we are promoting, we have to rank senior.
But
Same year.
Mr. Chaudhary, the persons over whom you are claiming
Yes,
seniority,
my lord.
they are not party respondents here.
No, they are respondents. They are respondents, my lord. Respondents, what I find is,
There was an IATA system.
yeah, engagement, I was given to understand that.
Because when the notices were issued,
Yes, my lord.
it was issued only to the official respondents. There is no reflection therein that it was. Mr. Naik, any parties have been implemented subsequently?
Respondents 5 to 184.
5, that is somewhere I found.
Para 15, page 9, my lord.
But I don't find them here.
Oh. Oh, it is pure. Up to 9.
Because if they were there, a notice would have gone to them also.
Correct.
So this recasting without, there is no IA reflected in the cause list also. I found that statement that you referred in para 15. I was referring to that only.
I was also under the impression.
I also was.
In
Then
fact, I
now
was
it's.
wondering why they're not before
Ah.
the court. But, can I do one thing, Milord?
Let Mr. Deka,
Ah.
let him have. You have made your submissions.
Yes.
Let Mr. Deka clarify on this. Because if they are not before us, how far this court can go?
That case, we'll have to make them, Milord.
Now, whether in 2012, after 13 years, we'll do that. Anyway, it's permissible,
Ah.
but whether it is permissible. And Mr. Chaudhary, one more issue. Your vacancy that is identified in 11(4)(c) is the next available
Next
vacancy.
available.
So the vacancies which have already been reserved for direct recruitment, whether that vacancy again can be construed for.
That's why I say there is a dichotomy, Milord. The problem is that if we go strictly by the various decisions of this vacancies arising in a year in Rule 22 unconstitutional. Thing there, Milord. But for that rule, I could not have claimed.
You have argued this matter, I think.
Yes.
Before him.
But my submission is that means you are giving promotion to somebody without even entering the service. They are giving retrospective.
There is
Therefore,
another.
arising of vacancy not furnish any cause of action for seniority.
No,
But
fine.
the rule says so.
But fine, let's go by the rules. But there's another issue here. The whole rule is structured on two principles or two parallels. One is direct recruitment, another is promotion. And this is done on the basis of a division of vacancies as far as AE is concerned.
Normally,
So
one is
even
not-
if your case is considered as a promotion, it being under the
Not under the
Direct-
normal promotion.
No, no, it's doesn't even refer to 13. It refers directly to 14.
14.
The APSC. If it is within the barrel, or if I call it the barrel of direct recruitment, now the 22-3 you have read,
Yes.
you can just come back for my,
Yes. A member appointed by promotion against the vacancy occurring in a year shall be senior to the member appointed by the direct recruitment of that year. There is no escape from the conclusion that Milord promotee has to be given a seniority there, despite the fact that
no,
occurrence of
but here,
an year is a calendar year.
no, if you just read the opening lines of para 22, the rule 20,
Seniority of a member appointed in a cadre by direct recruitment or
Or
by
by
promotion shall be determined according to the order of merit in the respective list finally approved by the appointing.
that is
authority.
immaterial.
No, my lord, my humble submission is 22(1). It deals with inter-C position
I'm
of
not on
the
that. I'm not on that.
different
I'm
group.
not on that, Mr.
Ah.
Chaudhary. What I'm trying to do, to understand 3,
Ah.
if we read the opening, just for my clarification, if we read the opening lines,
Yes,
the Rule 22 distinguishes between a direct recruit appointee and a promotee.
yes,
And you are a direct recruit appointee, although by way of promotion.
promotion.
But you are in the, because the division is very clear, direct recruit, promotee. So you are in the barrel of direct recruit,
The problem is, my lord, that 11(C) starts with a non-obstante clause.
notwithstanding anything.
That's the problem. Well, I think the whole problem lies with this vacancy occurring in a
The
year.
year.
This is giving me, furnishing me the cause of action to hesitate the issue. my
But
lord.
the only thing is that vacancy which is there, say they have to under Rule 12 or 11, 12, they have to before the end of the year ascertain
Identify.
that, identify that. Now, normally we will not say there will be a death. We will not say that. We'll go by anticipated vacancies. So the vacancy that is anticipated, that is involved in 11C is an anticipated vacancy.
Yes.
Other things may come. Somebody may die, somebody may be promoted, but it's basically this anticipated vacancy was already taken away under Rule 12 for direct recruitment advertised.
Yes.
So now if the government is to, APSC is to reserve one post for you out of that, would it not affect the recruitment process per se?
I said what has followed from, but the problem is this: the rule has been structured in such a way
We'll have to go by that.
that my lord, that the 11(4)(C) promotee, though he is to be construed as direct recruitment, he has been given a primacy because first available vacancy. There is no dispute that there was a vacancy.
I'm saying that. Before this exercise, 12 is already there. 12 says you reserve this vacancy, whatever you have identified,
Direct recruitment.
for
and
direct
promotion.
recruitment. Advertisements issued before even you came into the picture. Advertisement issues, recruitment process on. Now in February 2023, you clear.
But my humble submission is, subject to what your lordships may say, 11(C) gives an impression that the first available vacancy, even in direct recruitment, has to be given.
That's
to
what
me.
I'm saying. That is what I want a clarification from you.
Yes.
Now 12 says, if you read 12, before the end of the year, the
Yes, yes.
authority will reserve.
That means
So
making
whatever
vacancies
vacancies
which are available and which are likely to occur during the next year.
next year. So those existing, anticipated, they take it as a pool for direct recruitment and
By
they
the
advertise
cadre
it.
strength,
And advertise. Now you came in 23,
midway.
mid 23. No, you came in February, March.
No, February, September.
No. The clearance of your
Process,
examination.
process,
You cleared your examination, got your certificate sometime in February
February.
23. So now you come within 11(4)(C). So the next available vacancy you have to be considered. Now this next available vacancy, anticipated vacancy, is already taken to direct recruitment. How do you?
So question is, then we'll have to identify when the advertisement was issued, Milo.
I think
By operation of Rule 12, if the vacancies are there, it's
Already-
already earmarked.
already earmarked. Then what? This is
No,
something which I,
followed, Milo. But I was only trying to
because the
impress-
advertisement was there prior to that. Otherwise, the recruitment will not take place from February onwards.
was for direct recruitment. One second, Milo.
That date is not there. But if you go by your statement that the recruitments took place from February 23 to September,
Yes.
then it is that advertisement naturally is in
Must have preceded that.
2022,
Preceded that.
2002,
During that year only,
that year only.
beginning of the year.
The vacancies are of that year, cannot be of the earlier year.
No, my lord, therefore.
That two issues, Mr. Just something came up, maybe not
No, no,
relevant.
That's.
Mr. Naik, you also examine. Fine, give it to me.
To find.
Also inform the junior to Mr. Ken Chaudhary. Also inform the junior so that he can also factor in that. Mr. Chaudhary,
Yes.
this main thing that why the private respondents, what
That
happened?
is also, my lord, I'll have to ask my instructing counsel.
You will have to ask Mr. Deka. So what we do is we fix this matter. Next week,
Yes.
this court won't be there. So next week, we'll not,
Yes, yes, yes.
thereafter, the
Yes,
week
yes.
forwarding. No.
December.
13 years. We are not going to take it, add one more year to that. We'll finish it off.
Good
If
also.
if the respondents are not before this court, why should we pass any order prejudicing them? That let him have his instructions. Okay. As agreed, heard the Lana Council for the parties.
Yes, yeah.
However, the hearing remains inconclusive. Registry to list this matter again on Mr. Chaudhary,
Yes,
9/12/2025 for further hearing. 9.
9. I have a marriage in the family. I'll go
Oh.
on 10. No problem.
Oh, we can have it on 8th also.
8 would be
8,
safer.
8, after 8.
Deeply obliged.
Yes, Mr. Dotto. Have you seen the additional affidavit filed? You have not given a copy, madam, to the learned senior? No, wait just a moment. We can confirm it here. No, you have not given a copy. Why is this done? You have done to the public prosecutor, you have not given to him. Because this is a very basic document now. Mr. Dotto, you are assisted by? Mr. DJ Medi, Learned Counsel, assisting Mr. S. Dotto, Learned Senior Counsel, appearing for the respondent, submits that the copy of the additional affidavit filed by the by the petitioner on 14/11/2025, a copy of the was not furnished to them. Ms. P. Gupta, Learned Counsel for the petitioner, submits that a copy thereof would be furnished to the Learned Counsel assisting Mr. Learned Counsel for the petitioner during the course of the day. In view of the above, registry to list this matter again on site. I'll not be here next week, so I'm putting it on 4/11/2025. Mr. Dotto, any problem on 4th?
4/12.
4/12. Okay, 5 or 8,
is okay.
8, 5. Okay, Mr. We'll have it. You give the copy immediately.
Right now.
Okay. That day you were not here,
Yes, Lordship, I was
but I was somehow in your favor.
not in
I
my.
told
favor.
your junior to work it out. Have you worked out? What is the hierarchy? So if you have promoted her as district officer, why her fixation as development officer will not be given?
To find.
This is not with pay. Now fix her pay as development officer and then release to her the benefits. Revision, you have pension? No.
No.
No pension. Then prefixer pay as a district officer on a promotion. Release the areas as well as the pensionary benefits. You promote her as district officer without promoting her as development officer. I was against her all along. But now that will not require taking over a charge. Higher. Okay, you were promoted as. Oh, you were not. Oh, I got the district officer. Yes, district officer is higher.
Higher is
No, no, which is the hierarchy? District to development or development to district? Then gone. Because I was given the impression from your writ petition that development officer and then. Huh,
The charge of development officer initially,
huh, huh.
2004,
Hmm,
page 13.
hmm. Hmm.
The petitioner continued to
You come to page 17, the understanding of the petitioner,
district officer is higher, development officer is lower lot.
lower. Can you get a written instruction on that? We'll take it up at 2. Just a written instruction on that much only. One, you give me a printout. A competent, they'll write a letter, they will click it, give it to you, give it to me. So that we know, madam, you also have your instruction. We'll have it at 2. If it is the way I told, then that period cannot be left unattended. You will have to fix.
My instruction is, he was inspector, then he was officiated as the development officer, then promoted to development officer, he officiated.
He was not promoted.
He was not promoted. Then he worked as a, he was officiated as a
District.
the district officer. District of hierarchy is inspector, then development officer, then next.
Give me something. Give me something. If you want the relief, give me something. I'm ready to give you that. Any hierarchy somewhere? That is what I'm saying. Marketing officer is the highest. Okay. You get the hierarchy. I don't need your option. We'll have it at 2.
Yes.
And if it is the way I am understood it, then we'll we'll direct you to promote her as a development officer, release a benefit, refix, district officer, refix, subject to the instruction. Records have come. Take it up because without the records, there is no point in proving.
Because otherwise their affidavit is very vague.
Nothing is there.
Nothing is-
Yes, where is the records? Has he got the records? Mr. B. Kaushik Lana, counsel for the petitioner. All of it after some time. We'll see if the records are there, we'll finish it up. None appears for the petition on What is here? He was reinstated. No, he was, this is not the case. Penalties of removal. We'll say somebody comes, department proceeding will not. It's a
Item 25.
he has lost the bus now. That is the mistake of this court. We can't now, we'll go slowly, we'll let him come, we'll see. And they also have they want an adjournment. We can give you a short time. Let Mr. Nath come. He has expressed very big urgency. Let's see what is that. Yes. Time being today, because if that we take up that matter, there will be no other matter taken up. You have already done. Mr. Chaudhary is to reply. It's with regard to the tender prepare.
First was that, sir, amount
He literally agreed to that
second was the excise exemption, my lord.
exemption.
That issue, my lord, the judgments are there, which your lordship, you
That issue is already decided. And give me a small note on Friday. I'll be having a week time with me. I can then pass the order. On Friday, we will reserve it. We'll hear Mr. Chaudhary on that day.
hearing, my lord, otherwise.
No, it will not do.
I-
Heard
it's something lot.
heard Dr. A. Saraf, Learned Counsel for the petitioner, assisted by Mr. P.K. Bora, Learned Counsel for the petitioner. এবার লিখি পারে দুবার নহয় Dr. Saraf, Counsel, assisted by P.K. Bora, Learned Counsel for the petition. Also heard Miss L. Devi, Learned Counsel, representing Mr. R.K.D. Chaudhary, DYSGI. So, on the prayer of the Learned Counsel for the respondent, registry to list this matter again on 21/11/2025 for further hearing. We have heard him. We only want Mr. Chaudhary's response with regard to the second point. Give me a small note.
File,
Yes.
along with the judgments, my lord.
Along with it. This, who is there? This we'll have to hear. We'll have it in the first week of December. Second week, okay. From 8th of August. We'll fix it after 8th. As agreed to by the Learned Counsel for the parties, a registry to list this matter again on 11/12/2025 for division bench judgment. You have referred to that on 11/12/2025 for admissions. For admission.
Okay, my lord, this will be for this.
Endeavor would be made to dispose of the matter on the next date of listing. But this 11 we have heard, we'll finish it off.
I prepare the note, my lord, small.
Small note. Yes.
10 and 11.
This is Lordship. Item 10, my lord, there is an interlocutory application. Item 29 in the supplementary list.
Yes, yeah, 29 too.
Here, my lord, the thing is the petitioners, here 25 petitioners are there, they are tax collector, Panchayat department.
Hmm.
What happens, my lord? They are Now the government has published some advertisement for direct recruitment
What is this interlocutory application for?
or stay of the recruitment process, the appointment process.
Oh,
Because
now
my
we are
lord,
finally hearing the matter. Why should we?
My lord, it is now they are issuing, they are publishing the select list.
Fine.
That is the problem, my lord.
Now-
If it is not stated now,
Mister, we are disposing of the writ petition itself. If we come in your favor, the whole thing goes.
okay,
You make your submissions.
Lord, what happens? Rule 140. 140 of the Assam Panchayat Administrative Rules 2.
No,
Yeah.
no, before that, give me a background.
Background. My lord, all the petitioners, they are in the Panchayat they were elected directly, and they were recruited as tax collector from Road Mohara.
When?
What happens, my lord? They are working there. But in earlier cases, the Road Moharas were promoted to the post of secretary.
Just a moment. Petitioners were recruited as tax collector.
Tax collector come Road Mohara.
When?
Well, at different dates, my lord.
No, from when? Recently or 1990s?
Thank you.
90? 19? All?
Not, my lord. Different dates are there, my lord.
What is the earliest date? You are appearing in item number this Sondip
Ten.
Boyddo. Yes,
Eh,
2019.
Yes, my lord. They have been working accordingly, and in the earlier occasions, some were promoted to the post of secretary. And they were, in several cases were filed in the High Court, in the Honorable Court, and Honorable Court allowed for their promotion. What happens, my lord? 23, there was an advertisement for filling up 900 both some posts for different categories, but it is.
When was the advertisement issued?
Advertisement was issued, my lord, notification, Annex 10, my lord.
Page?
162. It's blanket advertisement, my lord, no this. But when it was published, then the right of information, got some information that out of 1,092 posts, 944 will be filled up by direct recruitment.
Now the breakup of the posts are not here.
Not there, Lord.
7,600 posts.
Yes, my lord. That is why, my lord, the,
And you say as per the RTI, or the reply that you have given,
yes,
1069 posts of 96. DP secretary involved. Okay. Now,
1944, for the 944,
Will be,
944 posts.
yes, my lord.
will be filled up.
No, that is promotion.
Direct recruitment, my lord.
Okay.
The petitioner has approached the honorable court that if it is their promotions are blocked, then ultimately they will have to remain in the same post.
Okay.
So
Now show me the rules or the provisions of the law. holding the field wherein you claim your promotion.
My lord. Rule 4, my lord.
Panchayat Raj Act.
Yes.
Panchayat. Rule section.
It is administrative rules.
Where do I get it?
Page
200.
220.
It is here in this book.
221, yes,
Where?
Two-
200?
21,
200?
21, my lord. It is mentioned salary, TA, DA and other allowances of provincial concerned employees. Here, my lord,
Staffing.
Administrative rules.
Yeah.
Okay.
lord, here,
Staffing pattern. The
Right.
following shall be
Habit-
staffing. Grade 3.
staffing pattern is there.
Secretary.
Staffing pattern is there. Town Panchayat, 3 posts, one is secretary, number 2, tax collector, come road mohora.
How is this supposed to be filled up?
Here it is mentioned, my lord, under the rule 4, this provision provided, last para, provided further that such employees of different grades in Jilla Parishad and Anshalik Panchayat and Gaon Panchayat within the jurisdiction of the Jilla Parishad shall form a unit of district cadre of Panchayat employees, and their promotion from lower rank to higher rank shall be considered inter alia according to inter se seniority of such employees within the district. The chief executive officer of respective Jilla Parishad shall cause to prepare an inter se seniority list of the Panchayat employees recruited under the provision. Well, as there is a provision, then if all are promoted, all are directly recruited, their promotion will be blocked. That is the problem, my lord.
Now, there are, in terms of your RTI, 1096 posts of GP secretary lying vacant. The government is only filling up 944.
Only 52 remains.
You are there.
It is not clearly mentioned.
How many in charge Gaon Panchayat secretaries are there? Section, this provisions of 140 is of the rules of the Act.
Even. Page 223, my lord. My lord, 2414, the post of Gaon Panchayat secretaries to the extent of sanction strength, the provisions of this one of the section 30 of the Assam Panchayat Act 1994 shall be applicable.
So come to section 140. Page
Fine.
141.
Yes, my lord. Sub-selection code. All the recruitment of grade 3 and grade 4 staff under Jilla Parishad, Anshalik Panchayat and Gaon Panchayat shall be conducted by state level recruitment commission for grade class 3 and state level recruitment commission for class 4 constituted under the Assam Direct Recruitment Commission. So and so.
So now if this is
It is
under
the
the Assam Direct Recruitment Commission,
commission.
so this post can be filled up only by direct recruitment.
It is not for the not for the promotional post.
Show me that distinction. This is the Act. This is the
Under
one
the
which
Act,
will have overriding effect.
Under the Act, the rules are framed.
No, rules cannot go beyond the Act.
But if it is so, then it is ultra virus.
That rules are gone. Because why I'm saying, so this provision of 140 was amended in 2023.
But in our case,
Was there a corresponding amendment or the rules after 23?
in our case, my lord,
Good day. Oh. 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 Wait, just a moment. We'll just finish up.
Yes, sir.
Yes, Mr.
My-
Monta, anything more?
section 30, maybe we can listen.
30?
30 of the act,
30.
page number 47. There shall be a secretary. One clause. And the other staffs as may be prescribed by the government, even in Gram Panchayat, who shall
So
be
secretary shall be appointed by whom?
except
I got it. You want to say these are two different category and
yes,
140
yes.
will attach to the second category. Okay, then secretary who will appoint? They themselves will appoint themselves.
they by promotion, secretary by promotion.
Okay. Yes. Yes, Mr. Pathak. Mr. Monta, we'll hear you if something more is there. We'll hear.
Okay,
Yes.
I'm fact handling the brief today for the first time, so my learned, correct me if I'm wrong on any factual.
No. We'll
Lordship
not,
has
we'll not,
freedom
we'll
for-
not proceed in that manner. You prepare, we'll have it
No,
on
why,
Thursday.
why I'm saying this? The other matter, and relying on that affidavit in our case also. The Lordship quickly has page number 36 of my.
Hmm.
There we have made a specific statement that these rules were notified in the year 2003. As per these rules, if your Lordship has page number 37, 5 sub rule 3, recruitment to the cadre of Gaon Panchayat secretary shall be made by promotion on the basis of amongst the tax collectors stroke road mohdars of the Gaon Panchayat Anchal qualifications of so and so or its equivalent examination passed and must have minimum continuous service of not less than 10 years in the cadre. So there's a scope of promotion. Now, in the affidavit that has been filed in the other matter, there is no
Reference to
reference
this.
to these rules. Now, one thing I'd like to point out to your Lordship, though a statement was made in the petition that these rules have been notified, if your Lordship has page number 36,
Not notified.
it says the word draft is there. So today I honestly cannot say for certain that if these rules have been notified or not. If they have been, then they'll perhaps change the entire picture.
Yes.
It's saying when it's pending.
It's under 141. 141 empowers the government to make rules under the act. So this is utilizing the 141 power. So why this was not notified?
At that time. This is amended only to 1, my lord. Yes, then my lord, it's saying pending finalization of service. The provincialized panchayat MPs to be framed under a proviso so and so. Or referred. Order shall be called in provincialized panchayat. Order, it's not. After the amendment of 2000.
Your Lordship has section 140 once again, your Lordship. I was insisting on this clarification.
140?
Section 140 of the Assam
Ah,
Panchayat
ah,
Act.
ah. Yes.
It says all the recruitment of grade 3 and grade 4 staff under Zilla Parishad, Anchalik Panchayat and Gaon Panchayat shall be conducted by the state level recruitment commission for class 3 and state level recruitment commission for class 4 constituted under the Assam Direct Recruitment Commission for analogous posts in class 3 and class 4 Act 21. Now, why this language was employed that all the recruitment, if your Lordship has the original section as it existed, it is there at the bottom of the page. Section 140 as it existed. Before substitution of the first paragraph in subsection 1 of section 140, Section 140 read as, for Zila Parishad, Anchalik Panchayat and Gaon Panchayat grade 3 and grade 4, staff shall be appointed by
The
the chief-
authority was changed,
Yes.
selecting authority.
Now, what this postulates is that in matters of recruitment, direct
Hmm.
recruitment, all direct recruitment has to be done by the board. But it does not say that promotion is barred.
No, it only says all grade 3 and grade 4 posts. So grade 3 in the staffing pattern, grade 3, number 1 GP is in the Gaon Panchayat is the secretary.
Secretary. So recruitment to those posts shall not be done by the chief executive.
What is this decision of this? Because I've not gone through your file. I was thinking that the same thing. I only went through that one.
Yes.
Page 42. What is this decision?
Your Lordship, earlier, some employees.
No, no, you go through it
Very
nicely.
good.
You
In
go
the meantime, if my learned friend files an affidavit in my matter,
Actually,
Alright.
this restriction is because there are some.
holding charge. Then
And
you
this-
had a new batch of secretaries coming in.
Somebody saying it's not permissible.
But they were direct recruits who had come in.
Yes. Your Lordship may kindly
We will have it. Let Mr. Pathak
saying directly.
formulate it.
Promotion.
Heard Mr. H.K. Monto and Mr. K.P. Monto, Learned Council for the petitioners in the above noted writ petition. Also heard Mr. S. Dr. Learned Council for the Learned Standing Council, Panchayat and Rural Development Department appearing for the respondents. So, hearing remains inconclusive. Mr. H. Burwa, also heard Mr. H. Burwa, Learned Council. Hearing remains inconclusive. Registry to list this matter again on 2nd or 4th, whenever, when you want it. 2nd, Mr. Monto. 2nd,
very well,
My lord,
2/12/22. There are still 52 posts vacant. And how many of you are here?
learned friend can.
Okay, 35, and in your case, how many? 24. 9, 59. Oh, we'll accommodate everybody if something. We'll ask Mr. Doctor to make supernumerary posts. But first, satisfy this court that there is a
would they have started the process?
okay, he'll file a contempt for that also.
I love.
Like,
My lord, I
$27 को दिया है तो थोड़ा सा ना कम मत करो। Yes, Mr. Nutt, what is your problem?
the work almost
What is the bar? But that order is not continuing. I don't find that order to be continuing. No, that was being extended from time to time, but subsequently it was not extended. Who is appearing along with Mr. Talukdar in this cases, or Mr. Talukdar is representing? Huh?
Other juniors, they went to their district.
And where is Mr. Talukdar? Huh?
What date, my lord?
Ask him to come online. Because when a seriousness is urged here, we'll have to give it some meaning because it was Mr. Talukdar who was expressing senior urgency the other day. He'll not be here for a week now.
But, any date, my lord,
Today, tomorrow, not beyond that. Today or tomorrow, whenever. Today at 2 o'clock, you can come online. We'll hear him. Because this order is not being extended with. We'll have to extend that order. For that, I'll have to hear you again. Because here, issue notice on the prayer of interim returnable on the same day. Meanwhile, there will be no eviction of the petitioner without following the prescribed procedure under the relevant statute. Now, this order was thereafter being continued with, but from 18/8/25, I don't find this order to be continued with.
the content is.
We have now come to the stage of disbursement of the money. But Mr. Nath, that you are here, just some clarifications. Their grievance is threefold.
Okay.
First, 3-1, right? Second, the reclassification of their land.
Land.
Third, the compensation amount being not prepared by considering the plots adjacent to their property. Third one can be taken care if they take the money also, no prejudice, they can go to a referral court. Second one is with regard to reclassification. I don't find from the documents brought on record that they have followed the provisions as mandated under 2015 Act. Apparently not very clear, subject to what Mr. Orbuzari would say. With regard to the first one, that is the contentious issue. Although their grievance basically is number 2, reclassification of the land. Section 7.1 you have done, but what about section 3.1?
Section 3 notices.
But have they received anything to show that they have received?
Many persons,
I'm not on that.
they have received.
These petitioners. Just a minute. Now, we are concerned with Goral, not with the Mirzapur, or both Mirzapur and Goral, 12 and 13. So, in Goral, how many persons are affected? Not on only on Goral. Then we'll come to Mirzapur. Mirzapur.
Respect of village or all.
Mirza, no, Mirzapur. There are 2 villages. One is Goral and the other one is Mirzapur. 24? Okay.
13 of 24, but others are 7.
In Mirzapur or Goral? Goral. Out of that, only out of that 25, 5. Okay, fine. 20. Out of 700, 20 only have a grievance. Other 700, other 680 have taken the money.
Once they are submitting,
They have not raised any dispute. In Mirzapur,
petitioners belong to.
from Mirzapur only one. The others have not. Make a statement on with responsibility, Mr. Nath.
my lord,
So LA case number 12 oblique 24. How many petitioners are involved there? Only petition number 6. This is Mirzapur.
Paldon Bajar,
Or be that as it may,
Lord.
we are concerned with the land. And LA case number 13.
all are
Okay. And how many people are totally involved in LA case number 12?
pattatars.
And in 13? And barring this 19, other 710 persons have raised no grievance. No, but here they have not received, they have not raised any grievance. Yes, Mr. Counsel. You could have given a memo yesterday, we would not have gone through it. There was such urgency that he had to go, you could have given a memo. We have gone through, because last date, both of you were expressing our urgency. Can I play that video back again to you? So receive your instructions. We are taking this matter at 2 sharp. Argue yourself or ask Mr. Talukdar to come online and argue. For 1 or 20, we will not allow a developmental project to be halted like this. You are only concerned with the interim order. I'll do that. I'll hear Mr. At 2 o'clock, I'll pass that order.
Offline.
That was it. 2 sharp, we'll take it out. Yes, Mr. Varpuzari, what is with this with regard to reclassification?
I say that is not at.
No, just give me a gist only. We'll hear you with him, along with him. So, there is a procedure prescribed. From the documents annexed, we don't find that procedure to be followed. No, I'm not on that. They have done it before that. They have brought on records documents showing that 22, 23 itself, they have submitted this application for reclassification. So reclassification can be done under certain very stringent conditions. And an affidavit is also required as to how. I don't find in 1 or 2 cases, some affidavits are there, the others, the affidavits are not there. So if the value of the land, market value is taken, is it taken only with regard to that land or in relation to the pattas that have been surrounding areas? If you take it with the value of the surrounding land, then I don't think they'll have any problem because the value will naturally go up. But what you have done is, you have taken the value as per the zonal value basing on the classification.
Code of
Now,
right.
what is the manner in which under the 2013 Act, the land value is to be fixed? Say this is a plot of land. Say it is fallow, it's just lying. But we have the other courts, say on the other plot of land. Those are big, big malls, big houses. So tomorrow when the land is acquired, the plot adjacent would be, forget the Zirat. I'm only with the land. The land say will be, because it's a commercial, it's a developed land, it will be taken as 1 lakh per kata. This land will be given 25,000. Whether that is permissible. But that permission was sought for by the petitioners, but you have not given that permission before that. And there is a time limit for that in the 2015.
Farmers lordship will there they had this honorable court that for
That is not there. That admittedly is not there. Because land lying fallow or land lying not attended, not cultivated, it's not a ground for conversion. You will have to show.
ultimately at the day everything then section 4 contemplates here in the case they might have preferred now here at
That accepted.
yes,
Now, tomorrow, just for as an officer of the court, they are not satisfied with the compensation. That is what I'm saying. Whether the classification of a land, just show me something on that at 2 o'clock. Just because that is the area where the concern lies. Just show me something that this issue is also permissible to be raised before the referral court. Just
yes, definitely.
no, but I want to know whether any prejudice would be caused to the petitioners. Just because this would be a law laid down. That even if we say that, okay, fine, this court is not considering the matter, they'll have to go before a referral court. Whether the issue being raised before this court not having considered it, whether the referral court would proceed. 2, whether this court can direct that this issue is kept open. To obliterate both, I want a decision that this issue is otherwise also open to be considered before the referral court. Because that will cause prejudice to none if that decision is there. Just show me that decision at 2 o'clock. First item. Yes, Mr. Gusam. Yes, he has already made his submission.
Yes.
Is it audible to you? Are we
My
audible?
lords, my lords, it's no, my lords, the concerned council, what is arguing, it's not audible to me.
Mr.
You are audible to
Goswami,
me.
come this side. There's some problem with the mic. You can come this side. You can come this side. একদম দিগদারি হয়েছে।
kindly have a look at page 30, my lord.
Page 3,
30, my lord, annexure 2.
30. Yes.
Tender, my lord.
Hmm.
Annexure 2, page 30.
Hmm.
Lordship, clause 3(1). Specification covers the following scope of work. The scope of works under the subject package includes site survey, planning, design, engineering, assembly, manufacturing, testing, supply, loading, transportation, unloading, insurance, delivery at site, handling, storage, installation, testing, commissioning, and documentation of all items, material required to complete the DTR metering works in all above 3 packages.
Where is the explanation of this?
My lord, that is, your lordship, then my lord, to act, my lord, to,
No. That this, what you have said here,
my lord.
that this also includes construction activities.
Yes.
How do we infer?
Yes,
Where is the material to infer that?
yes, my lord, this is not that, my lord, what he has, my lord, my lord, apprised this honorable court. This is absolutely a matter relating to only supply of material.
This is supply of material.
Yes, his cases. But
That-
my case is,
Okay. Come to page 34.
yes. 33, my lord. It starts annexure 3, my lord,
Hmm.
page 33.
That is the
LOA,
LOA.
annexure 3, clause 20, my lord,
Hmm.
award of contract. We confirm having accepted the bid so and so in conjunction with all specification terms and condition of the bidders documents referred to above award to you contract for the complete decision of the proposed work against the APDCL so and so package of Deen Dayal so and so. Then lordship, 212. Execution of supply, construction and commissioning of
Distribution transformer, not of a
Yes.
building.
No, my lord, rule says, act says, my lord, building and other construction.
We'll come to that. That is already
Yes.
interpreted. Building in connection with
Yes,
that.
yes, my lord, not
Yeah,
only.
you show me that they are doing they're constructing a building.
The petition, no, here is not a case that this is relating to, it is also clear, my lord. This is not in connection with construction of building, my lord. Other construction does not necessarily mean, my lord, only the construction of building, my lord. That is my respectful submission.
Show me. Total cost of erection. You come to clause 3.1.
Yes, 3.1.
One. Contract price.
So and so. Yes, next part is erection part.
So there is a clear supply of a part.
Yes.
Clear supply. Let us accept your argument
Fine.
also that there is a construction element involved, for which cess would be. But how can you bring in the supply part to that?
Supply part does not come, my lord.
You have taken it as a whole.
But other parts is there, my lord.
You have
My lord,
taken
your
the-
lordship will kindly see, my lord. The petitioner was asked to submit the documents, my lord. In respect of his works completed, my lord.
Okay,
He
you
has
proceed.
failed to do so.
You proceed.
If you'd have, my lord, submitted all these documents, my lord, everything would have come clear, my lord. That is also, and my lord, it's an estimated cost. The estimated cost.
So, where is your
My lord, that is why it is abundantly clear that so far supply is concerned, no cess can be levied, my lord, and construction does not, my respectful
so
submission is-
because he did not support
petitioner
with the-
except referring the provision of law, my lord.
did not
How
bring
he-
in.
Yes, he did not say anything with
Hmm.
regard to the works, my lord.
Hmm.
He has done, my lord. He only emphasized the, my lord, provision of law and the judgment of the Supreme Court, my lord.
What do you have to say from the act? Any provision you want to
Yes,
tell us?
my lord, your lordship will see, my lord,
Building
First, my lord, your lordship will see
এতো দিয়েছো।
Act, my lord. 1996 Act, my lord. Go CW
Building and other construction workers welfare cess act.
or my lord 2D first, my lord.
Just a minute. Building and
I read it, my lord. 4D. Sorry, 2D.
yes,
Building or other construction works means construction, alteration, repair, maintenance, or demolition and or relation to buildings, street, road, railways, tramways, airfields, irrigation, drainage, embankment, navigation work, flood control work, including storm water drainage work, generation, transmission, and distribution of power, water works, oil, gas installation, electric lines, wireless, radio, television, telephone, telegraph, and overseas communication, dam, canals, reservoir, water course, tunnels, bridge, viaducts, ediducts,
yes. How
Fine.
does this apply in this case?
my lord.
How does this
Yes,
definition?
my lord, the construction, other construction includes, my lord, because his case is only, according to the petitioner, he supplied the material. That is his case, my lord.
Means construction, alteration, repairs, maintenance,
My lord.
or demolition
My lord. And,
of or
yes,
in relation to these.
my lord.
Now, where is the construction activity taking place here? Alteration taking place here?
Yes,
Repairs taking place here? Maintenance
Yes.
or demolition?
yes, my lord, indeed, my lord, as your lordship has already, my lord.
The erection
noticed-
is, Mister, this is a electricity meter.
My lord.
Only that it has to
No,
be
not
fit.
only that, that is why, my lord, that is the problem, my lord.
This is what I want you to answer.
That is why, my lord, we are referring to Annexure 3, my lord. Clause 212, execution of supply, construction and commission, that is there, my lord. And everything is not, my lord, explained here. As such, but that is there, my lord. And petitioner has not stated anything except saying that his case is only supply.
Okay. Yes, Mr. Counsel. How do you respond to that?
My lords, my whole case revolves around the LOA, which I already annexed with the petition, my lords. If we see, my lords, page number
That is, my lord.
33.
So that part is my respectful submission is
So, my lords, if we look, my lords, page number 33.
Yeah, Mr. Goswami's, the Leonard additional ages contention is
My lords,
that as far as the supply part is concerned, you are not covered.
my lords,
That has to be excluded.
my lords,
But he says that the erection part, it
my
being,
lords.
when you read it in conjunction with section 3,
My lords.
1 of at page 30.
4.3 is also there, my lord. Rule
Huh? 4.3.
2D definition, my lord, and 4 rules, my lord. 98 rules.
No, we are not on that. 3.1 of page 30 of the
Yes.
paper book.
My lords.
How do you bring it? How do you explain this? 3.1. Am I audible?
My lords, you are audible, my lords. I'm just
How do you
looking up.
explain clause 3.1 at page 30 of the paper book of the writ petition?
That's what I'm looking for, my lords.
Annexure 2,
Next,
Bottom.
that's a 8 and a notice, my lords. That's come the bottom.
bottom. How do
Well,
you say that this is only a supply work? There is no construction activity
Since
involved.
my lords, again, I need a clarification since like my petition most rely on the LOA part where my scope defined under clause 4, my lords.
Because
We see Annexure 4,
there is a heading erection.
my lords. So erection is all about installation, my lords. If we see section
If
2 1D,
erection comes here, if you come to the scope of the work in the e-tender,
my lords,
it involves site survey, planning, design, engineering,
my lords, my lords. Again,
assembly,
coming on,
manufacturing,
my lords.
testing, supply, loading, transportation, unloading. So now, if we read that into the definition of building and or other construction work, so it generation, transmission, and distribution of power.
Malts.
So
If we see Malts, again, section 2 1D of the BO Suitable Act, Malts is bifurcated into three elements, Malts, three parts. First is
no,
Malts.
we leave the supply part. Supply part you are not entitled to cess.
Coming
But what
again
about
on
the
the
other
erection
two?
part. Again on the erection part, my lord, since it's all installation, basically what my object, which I specifically defined under LOA, where it's explicitly defined that my whole sole scope revolves around the supply part and the erection part. That is installation of the meters.
Installation of the meters, yes.
Well, if we see page number 34, where my scope of work defined, my lords. It's Malts.
You are relying on your LOA. Let us
Malts.
come to 2.1.2. What do you meaning will you give to this construction? Supply, construction,
Malts.
and commissioning. Here it
Malts,
is supply, erection,
erection and commissioning, my lords. If we see scope of work, point 4, that specify that turnkey
Point 4
design,
of the
supply,
LOA.
erection, and commissioning of LOA. Page number 34, my lords.
Ah.
That's confine my scope of services. Since e-tender is something of wider scope, and the LOA is somewhere like where I'm executing after e-tender, where my scope of service being defined. So
It
under
cannot
clause
be
4,
something, is it your case that the scope that was there of the work in the e-tender was narrowed down while issuing the LOA?
well, somewhere, my lords, my scope of work or my billing, it's all depend on the LOA which I am executed with the department.
So you are
So
doing
what-
something in connection with a building. In connection with a building, you are doing something.
In
So
connection,
now
yes.
what is that construction, element of construction here? You come to page 33.
My lords,
Read the subject. Letter of award for execution of supply, construction and commissioning. Now, what is this word construction here? Because the building or other construction work means the construction, alteration, repairs, maintenance or demolition of the building or in relation to the building.
my lords,
So this will come in relation to the building.
my lords.
What is the construction activity there?
Well, here again, there is no construction activity, my lord. Since my scope of work again depends on and solely rely coming under LOA part, where it's
The
bifurcated
LOA
into two
itself
elements.
says that it is
Erection.
supply, construction and commissioning.
Again, my lords, again, coming on the BOCW rules and the act, my lords, though it's much clear under section 2 1D that my whole solely part where I'm relying under this petition is erection and supply. coming on the rules, my lords, rules 3 of the cess rule, where if in case
Rule
3
of the,
cess rules, my lords.
okay. Okay.
So what it says, in case if there is a conflict, state that, my lords, if my lords allow, I would read rules
Hmm.
3 that cess would be deducted on the cost of construction, which shall include all expenditure incurred by employer in connection with building and other construction work. My lords, it's again understand, it's relevant to understand the definition of contractor, whether I am contractor or not, covering under BOCW Act or not. My lords, if we read definition of contractor, my lords, it's 21G, my lords. Contractor means a person who undertake to produce a given result for any establishment other than a mere supply of goods or article of manufacture by the employment of building workers or who supply building workers for any work of the establishment and include a subcontractor.
So if it was a mere supply,
My lords,
say you just give APTCL X number of meters.
my lords,
That is, you are out of they cannot levy cess on you
my
under
lords,
this act.
my lords.
But if the work also includes a construction activity on a building, whether the provisions to the extent of that construction activity be liable to cess under this,
My
leaving
lords,
the, because there is
see.
a word used, erection, and the scope of the work in terms of the letter of award is supply, construction, and commissioning.
My lords,
So what you are saying is 1 and 3, supply,
lords.
commissioning. What
My
about
lords.
the second word? Erection.
My lords,
I'm just trying to, the argument of Mr.
my lords.
Otherwise, this seems to be a total
My lords,
case of supply.
my lords, it's completely case of supply, my lords. If we see LOA even,
But the AG has raised the issue.
my
You have
lords,
to answer that. What is your reply to that? What is this construction?
my lords, again, I'm not a construction company, even I'm not a contractor coming under this BOW
It
Act.
not be, but if you are a contractor involved in a work covered by
Well-
the, which can be said to be covered, because these are beneficial legislations,
My lords,
to be covered by this Building Act of 1996.
my lords,
To that extent, the government can levy cess. To that
my lords,
extent. The decisions of the Supreme Court also says that if there is a mixture of supply and construction,
my
to
lords,
the extent of construction, this is liable.
liable, my lords.
So just give me an idea as to what this word construction and here that is being included as erection means.
Though, my lords, being a public listed company, mostly dealing into supply and the erection, my lords. Apologies, my lords, I'm not aware about the construction part, since, my lords, I'm not
It's
involved
there.
in my scope of services.
Mr.
Though
Mr.
it's written.
Counsel, Mr. Counsel, there is a
Yes.
clear-cut specification of that in the LOA. Page 33, subject. Come to page 33.
A letter of award for consumer metering under RAR.
No. Letter of award for execution. Subject. Page
Once again-
33.
Again, my lords, they are two specific tenders, my lords, related to the same activity. So the
What
LOA
you have brought in as
which I am
Annexure
reading,
3.
the subject
Annexure
part,
3.
my lords,
Annexure 3.
my lords.
Just have Annexure 3, subject. Have we got it?
Also, again, the LOA part which I have like in under page 30, my lords, 33. It's somewhere written under this headline of subject is scope of work. where turnkey, my scope of work defines that turnkey design, supply, erection and commissioning. There is no word of construction, my lords.
Where do I find that?
Apologies, my lords.
Where do I find that?
Page number 34, my lords.
34, yes.
So this LOA part, which I'm reading,
2.1.2. Right?
my lords.
Supply, construction and commissioning. What is that construction involved there? Commissioning I understood, supply I understood. What is that construction? It is in relation to a building. Or
My lords, it's somewhere, my lords, again, I need to have a getting
you have your
clarification from the concerned
clarification.
department, my
When
lords.
can you get it?
My lords, allow me a day. Allow me a day. So during the course of the day, get me a clarification from the concerned department who actually dealing with this aspect, that whether
Fine, no problem.
my lords.
But Mr.
But my respectful submission in his petition, that he
Nothing
has
is
not
there.
stated, my lord.
Okay.
Apart from that, my lord, this was included in the estimated cost,
We'll have it.
my lord.
But
And my lord, lordship.
Mr. P. Goel, learned counsel for the petitioner, also heard Mr. B. Goswami, learned additional advocate general. Mr. Goswami has raised certain issues in the matter which pertains certain issues in the matter with regard to the nature of the contract awarded to the petitioner and the scope thereof. Mr. Goswami has contended that the scope of the work in scope of the contract granted to the petitioner company also includes a construction activity in addition to supply and commissioning. Accordingly, he submits that to the extent of the construction activity carried out, the cess would be leviable.
That is
So-
why, my lord, that cost of
Post with the above issue, Mr. Goel has submitted that he be granted a day's time to receive his instructions from his client. Also, raised it to list this matter again on 21. 21, Mr. Goel, any problem?
My lords, it works.
Very
21. That's
21 at same night on me last. Or can we skip a week and have it on the 1st? Because I'll not be here for a week. On the 1st,
well, it's again,
On
it's
one-
your discretion, my lords.
1/12, you come online, there is no problem.
My lords, my lords.
1/12/2025. Huh? Go further
Well,
here.
Oh, sorry, my
My
lord,
lords.
I have problem.
2, 4.
Will I say?
Or we'll have it on 21st. 21st of Doradri. No?
Oh,
Well,
no
it's all
problem.
about giving clarification on this construction part,
Getting
since like the
There is no,
LOA
what
which I have,
problem is 21st would be my last sitting here. Thereafter, I'll be going outstation.
my lords, my
So
lords.
maybe I'll not be able to do complete justice, give time. So
My
let us have it on 4th, 4/12, for further here.
My lords. Much obliged, my lords.
Mr. Goel, have that instruction, but
My lords, my lords.
otherwise, tentative view was with you.
My lords.
We'll consider.
My lords, my lords.
Well, this is the case of transfer, my lord. Come to the transfer, impugn transfer order. Case number 19. But I was working as a shift manager, for 2. Deep Bora. But I was working as shift manager technical audit. I have been transferred to shift manager materials.
What is the error?
Error is not, error is that, Bharat, if a lordship kindly see the in transfer order, here it has been written,
Page.
same page, my lord, page 19. They have put some conditions also, my lord. The controlling officer shall release the transfer executive before the cutoff date. That means, my lord, there is a cutoff date. It shall stand released automatically. The cutoff date. Third is, my lord, second, number 3 is that if you do not join, that will be considered as unauthorized absence. Lastly, my lord, number 4, no extension of the cutoff date. These are the criteria in the impugn order, my lord. Thereafter, my lord, govern our transfer. It is a inter-departmental transfer, rotation. So to govern this, but there is a policy. HR
Interdepartmental transfer. Hmm. Now, what is this error in this
Yes.
3?
Lordship may kindly come to the page 21.
No. Page 19 clear of what is the error.
But error is there.
Forget the transfer that you will have to justify. But with 2.0, 3.0, 4.0, hold that the transfer orders are genuine,
Genuine.
upheld.
Upheld, madam.
Then what is the error in 2.2 to 3.0?
Is that if you do not join,
What is the error in putting that state? But that
this is a stringent conditions, my lord.
is
Have to be complied.
there any error in putting that? Any right of yours have been violated because of this conditions?
Person may be absent on taking leave.
Some may be absent, that is a different, but what is
But
the effect?
I applied for leave. That was not granted. So showing the
The employer says that I have passed this order,
order.
comply with it by 29,
Yes, madam.
right? What is the error?
No cutoff date.
What is the error?
Very stringent, madam.
Show me the law that such conditions cannot be incorporated.
Also, madam.
Now,
Before that, madam.
before that will come. I'm not on the, I want to understand the challenge to this order on the ground of cutoff date.
I'll come, madam.
So,
Let me kindly show me page 21, madam.
21.
Madam. Clause 6.2.4 regarding the transfer, how a transfer is to be made. Yes, madam, the process of interdepartmental job rotation will be as follows. Personnel department shall provide the list of executives who have completed more than 5 years in current department and due for rotation by 38 September. Till such time the information is available in the database, the list shall be generated by the concerned department. SOD, this is very important, SOD in consultation of the group head shall submit the transfer policy to the personnel department for processing the transfer. I'm on this, and next point, 6.2.5. It says that interdepartmental job rotation in field up to grade F shall be placed normally.
These are guidelines.
Yes, ma'am, these are guidelines.
Guidelines have got no justiciability. You can't base your transfer order on the guideline.
Or relying on this grounds.
They cannot. This is just a guideline. Violation of this will.
Yes, if
Huh?
otherwise I don't have any case, madam.
But here there are 3 persons involved. The other 2 has got no issue.
I'll show it. I'll show you, Lordship, madam, how they are not affected.
Oh.
Madam, on a clear reading of these 2 clauses, 6.2.4, 6.2.5.
So your case is only by violation of 6.2.1 and 6.2.
2.4 and 2.5.
Only
This
whole case.
And I'll show another matter. It's my first representation is still pending, madam.
What do you want? Representation disposal, merit hearing,
Sorry.
or a dismissal?
After hearing the case, madam, Lordship may
No, if you have something to say, once we make up our mind, either way, we allow it, we will not consider his thing. We dismiss it, we will not consider your prayer for representation disposal. Your prayer, you can make whatever you want beforehand. What? Representation.
No, after Lordship. After your Lordship, madam.
Up to me.
Yes, madam. Yes, unlike this, after your Lordship, let me submit first, madam.
Okay.
For
So your first submission is violation of
HR policy number 6.2.
6.2.4 and 6.2.5.
Both these my points, madam, they are silent in the
Okay.
It's completely silence, madam. They are showing some other clause, which I do not follow. But thereafter, madam, I filed a representation. Yes, madam,
20?
24. Annexure 5. But this has been acted partly that it will not be allowed. They have relied the conditions which are shown in the implement transfer order. That these are the conditions, you have to follow it.
No, this is your representation.
Yes, madam. After
For?
this, for keeping me in the in other department except this
No,
Can-
keeping ye,
any other department. My prayer is
okay, for
to post me anywhere
keeping oblique
except-
transferring in any other,
department except material, contact and purchase.
yes.
After this, madam, I again filed a representation, first representation, that is next page, madam, at page 25.
Hmm.
Here I have quoted those two clauses,
Okay.
6.2.4 and 6.2.5. This is still pending, madam. They have not acted upon this.
Now, that you are before this court, why should they act upon this? We are now considering.
Yes.
The earlier one also not disposed of.
But that have been disposed. They have shown that since there is a condition in the implement order that that should be not extended, there is a cut-off date. Any absence, it will be considered as unauthorized absence.
Where is that disposal order?
But, they have filed their affidavit, madam. Lordship will the affidavit. As per the implement order, Lordship has at least seen, madam, that there is a specific time for transfer. Why they have transferred after March? This order was issued on July. Why they have done it? They have no answer. And my lordship, if your lordship comes to page 66 of their affidavit, kindly come, my lord.
Is that?
But this letter, I filed an RTI to get this letter. Luckily, my lord, I've got this letter here in the affidavit, my lord.
I'm not on that. Where is, you said there is a order
I'm
disposing of your representation dated 24/7/25. I'm stuck there.
for that, kindly, my lord. I'll
Before that also.
for my page 66, my lord. There is a justification regarding the transfer of the three incumbents. Justification is that, my lord, lordship will kindly see. Number one is Indro Kamal Kolita. Lordship at page 66, Indro Kamal Kolita is there. Here, lordship, if your lordship read, my lord, the remarks. GM technical audit, file letter number so and so, dated so and so, duly approved by CGM audit, has proposed transfer of so and so from so and so to so and so. That means, my lord, this has a this has been complied as per rule 6.2.4. In serial number one, they have complied 6.2.4 that the SOD in particular of the group head shall make a proposal. If your lordship comes to the next page, page 67, where my name is shown, my lord, with Bora. In the remarks part, my lord, if your lordships kindly peruse, my lord, Sri Bora has joined so and so in material in the year so and so. Then after working in the material for 8 years, Sri Bora has been transferred to so and so, the year 22. Bora has again transferred the technical audit department where he is. Here, my lord, they have not taken any approval, my lord, which is mandatory, my lord, for their own rule. for the incumbents number 1 and number 3, they have taken the approval from the SOD and the group head.
Under 6.2.4.
Yes, as per 2.
Okay.
This approval has not been taken.
Come back to 6.2.4.
At page 21, madam. Personnel department shall provide the list of executives who have completed more than 3 or 5 years in current department and due for rotation by 30th September, madam. And not July. Till such time, the information is available in the database. The list shall be generated by the concerned departments. SOD in consultation of group head shall submit the transfer proposal to the personnel department for processing the transfer, madam. Your Lordship peruse page 66 of their affidavit. In case of incumbent number 1 and incumbent number 3, they have taken the approval, madam. In my case, madam, no approval was taken. And I sought this letter from them by RTI. Till today, they have not punished me, madam. That's it.
Yes.
Now, my lord, they have said that they have also violated this clause, my lord, by saying that as per their affidavit in opposition, my lord, they have annexed the delegation of powers. Who will do what? In my case, my lord, in my case, my lord, in the first day, before my lordship was passed, this bench was obliged to pass an interim order. They came out with a false information that the approval has been taken. And secondly, saying that they have acted as per the power of delegation, which they have annexed. If your lordship kindly come to my lord. My lord, page 105 of my reply. In my reply, my affidavit, I have mentioned, my lord, the Honorable denies the same. As per the impin order dated so and so, approval was taken from executive director, HR and FA, instead
not
of
from-
executive director, my lord.
Audit.
My lord, audit. For transferring.
So this is your case.
Yes, this is my case. And now, my lord, now what they have done, they have amended the provision, my lord, after filing up this petition. Yes, my lord.
Yes.
My lord, lordship may kindly come to page 129. My lord. Lordship will find it, my lord. Item number A11, A subclause 3, interdepartmental transfer. The concerned authority, my lord, who will make the transfer?
This is subsequent. This is of no use.
No, my lord. This is they have violated, my lord.
Oh, this is subsequent.
No,
This is not there when this is the amended provision.
no, my lord. before the amendment.
This is before.
Yes,
amendment?
my lord.
Okay.
Before amendment, my lord.
Page 129.
129, my lord. And who will do the work, my lord? On concerned controlling officer, that is ED, executive director.
Now, which department do you want to go?
My lord, I want to the any department except the materials on.
Why?
Why, my lord? During my stay in that department, I have to suffer my promotion, my lord. For that, I have monetary loss, my lord. My increments are not increased, my lord, due to my late promotion, my lord.
Because of
There is
the,
something there, my lord, that those persons are not promoted, my lord, in time.
how far, what is your length of service?
My length is from 2009, my lord.
9.
These are their own, my lord. And now they
years.
have amended this.
What is the period for voluntary retirement in the organization? Compulsory retirement, voluntary retirement?
20 years, my lord, 20 to 25 years.
Yes, 4 more years. Which is the department you want to go?
Any department.
You tell me.
Any department.
What are the departments?
Not of my choice, my lord.
Mr. Kolita, we are posting him somewhere.
Any department, my lord.
department?
Any department, my lord.
Which?
No, no, I do not have any choice, my lord. Except
Where are
this-
you now?
I am now, my lord, I am now in chief manager material, my lord. In that department. Except this department.
Audit.
Any
You are
other-
in audit.
Madam.
Huh?
anything, my lord. Any, my lord. Any department.
Okay.
Except
What is the, you are in which place?
Present, my lord.
Duliajan. Where are other officers?
Other, but these are not transferable, my lord. These are, we
Not transferable posts.
right here, my lord. These are interdepartment transfer, my lord.
Not transferable, Mr. Kolita. Transferable posts.
But this is regarding interdepartment.
Where are the posts available in India? Post him outside somewhere. He's having some problem there. Why don't you post him somewhere in Gujarat if you have an office in Delhi,
But that will affect me, my
Calcutta.
lord. That will affect me, my lord. If-
Calcutta.
If it is a routine, my routine transfer,
Calcutta? We are giving you that liberty. Pass that order, come back. Do not make a person suffer like this. Okay. Where is that? We'll provide for that. Don't worry. Then
Lord,
you seem to be victimized in Duliajan. Somebody, that is, I think, your grievance. You are being victimized there. So you'll have to be taken out of that place. And where is the representation disposal
my lord,
of
if-
your representation dated 24/7/2025?
Page 125,
1?
Read, my lord.
But this is not the representation.
Yes, my lord.
No.
They have disposed it. This is the way, my lord.
This is with regard to your extension of time for
Yes, my lord.
joining.
Yes, my lord.
Page 71. 70. Yes. That. Okay. Okay. Now, show me the allegation of malafide.
My lord, they are silent on 6.2.4.
No. That is guideline. Gone. SL Abbas.
This is on-
SL Abbas and onwards. SL Abbas and the line of judgments thereafter. But where is malafide? Biasness. What is your allegation? Violation of statutory provisions.
My transfer was made upon my request. If a lordship comes to at page 126.
On your request.
Yes, my lord. They agreed earlier. Now they are denying it.
So you are still continuing in audit department.
I've been transferred
Where?
to contact and purchase material.
Join.
Join. Because there is no cut-off date, my lord. No extension granted.
120?
126, my lord. With due respect, I would like to, I would like to inform you that I have been working in this prestigious organization as a member of group since 2008.
Okay, show me how you have been deprived. How you have been deprived of your monetary and career view. You're not being paid your salaries. Then what is the monetary loss occasioning? That you are gaining in audit and not gaining in CNP.
Anywhere, my lord.
What is
anywhere
that monetary benefit?
My lordship may kindly come to page 111.
Huh?
Page number 1, 1 and 1.
111. I've been coming and coming, but not getting anything. Yes. Yes.
The last paragraph. I
Huh.
was deprived from his promotion from grade C1 to D. Just D1, 1/1/2017. I was promoted on 1/1/2018. On air, my lord.
Why? Why? What is the reason?
Answer that those.
Have you challenged this? Then
I am on the
it is because of that policy, Mr. That 30%. So if it is 30%, then 1/1 of the previous year. And if it is 30%, this is no. That is the policy.
my case is on my
So if this is because your merit or something was found to fall in 30% or 70%? So 30%, 77. So you came in the 30% block. So you were promoted with the,
but that has not been mentioned in their affidavit, my lord. Let them reply, my lord, to that. I'll reply, my lord.
Yes, reply, in reply.
Yes, my lord, I've not got it, my lord.
now show me the justification. Show me the justification for this.
Justification.
Then just to project something, Mr. Das, we are imposing cost on your client. Don't worry. This is not the way you deal with this matter. Sorry. Anything more? Till now, you have not shown me a genuine reason to come to your favor. Just beating around the bush. And this is the deprivation which you have been saying we will provide in our order, that you have misled this court. Because you have not challenged. This cannot be projected. You have wasted the time of this court.
Over, my lord, my
What is he? What is he? Chief manager.
friend.
So nothing less than 1 lakh. Yes, anything more?
My last representation, my lord, which was filed, my lord, at my lord, last page, my lord. But
Okay.
that has not been disposed of till due day, my lord.
I told you in the first instance itself.
25, my lord.
I told you in the first instance, if we come against you, we are not going to revert back to the representation.
Page 25, my lord. Have been disposed of, my lord.
It not be. Now we are here, we are considering. So we are dismissing your writ petition subject to, after hearing Mr. Thing, cost 1 lakh. Yes, Mr. Kulta. $126.
Yes. 9, 10.
9, 10. Okay, fine, forget it.
Department is the materials department. And his confirmation.
Tell me the paragraph.
Lordship, I have 6 and 7. May I read, Lordship? Where he worked during the period 2000.
Forget it. No reason has been so.
We have awarded in Philippine law.
Para? Hmm.
Of relation and transferability. Without issuing any document with the approved
Not the case.
in the
Whether this clause was mentioned, have any definition? Maybe mentioned in my reply, my lord.
Challenge that provision. 0.4.1. Challenge.
That is not, they will not cover me, my lord. And this is also not mentioned.
Yes, next. Next.
a reading of the above proved without the need for it. Level 1 officer. Or to be approved by the council. That is the general manager, executive. There is therefore no edifice. Other submitted the person. The other
Anything more? Anything more? The ground which is left out now is your deprivation in your career progression because of something in the CP, materials department. Now, you have made a statement in your writ petition also to that effect. They have replied to that. Come to page 39 of their affidavit, the part of para 22. Have you got the second paragraph? Huh? So they have said that. What is your reply?
My reply is, my lord,
Where? No, your reply to this paragraph, para
Yes, sir.
22 of the affidavit.
Okay.
I'll help you.
Just,
Page 111, para 13.
just move. Yes, ma'am.
Now tell me, they say that everything is because of your performance in this. Where have you denied that? Saying that, no, I was subjected to hostile discrimination. That's why I don't want to go back there. Where?
Communicated to me, madam.
Need not be. They have said that,
Anything adverse has been passed against me.
sorry, Mr. Das, you may not know, your client knows about it. Why he was not promoted. That reason could have been challenged by him, saying that my merit was not properly assessed. Right? There are different criterias given there. So this is a case, nothing is worked out. We have wasted our time. We could have taken up 10 more matters pertaining to pension. We have lost out on that. How much cost? I'll impose cost. With reasons. 1 lakh or more. Mr. Kolta, 1 lakh would be fine. Heard Mr. SP Das, also heard Mr. K. Kolita, learned counsel for the respondent. K. Kolita, learned counsel for the. No, SP Das, learned counsel for the. K. Kolita, learned counsel. Hearing remains inconclusive. Registry to list this matter again on study 20. I'll pass the order on that. And Mr. Das, 1 lakh. For
They are silent.
for filing this frivolous petition.
Okay, I have
no.
tried to convince your lordship by showing their clause, whether they have taken the approval or not. They have not taken, my lord, as per their document. They are silent on that.
Guidelines.
And my entire case is on the guidelines, my lord. Starting, I the lordship that
Today it's 1 lakh. Let's see how much it goes up till 20. This petition should be stopped. This type of petition should be stopped. You have not alleged any malafide. You have not alleged any violation of statutory provisions. You have not alleged that the post that they were supposed you were transferred to was not a post which was as per your entitlement. These are the 3-4 spacious grounds where we can interfere. Otherwise, we can. And we have been wasting time with you. But we gave you full hearing. We wanted something. So now we are entitled to impose cost. That I'll decide on 20th.
Good.
Yes, madam. What is the instruction? You are not the government. You are not the government. You are for director. Who is for the government? Oh. SD Learned, Standing Council, Health and Family Welfare Department has placed on record a communication dated 14/11/2025 by the Director of Health Services bracketed FW bracket over Assam, wherein a proposal for sanction and drawal of area salary in respect of the petitioner has been sent to the government in the Health, Roman and Family Welfare Department. Also, Ms. Deborah submits that she will receive instructions from the government in the Health and Family Welfare Department with regard to the processing of the said application and prays that the present writ petition be taken up on 10/12/2025. Prayer accepted. Registry to list this matter again on 10/12/2025. A copy of the communication dated 14/11/2025 furnished by Ms. Deborah is kept on record and marked as X. 14/12, sorry, 14/12. No, 10/12. 10. No problem, 12/12. Mr. S.K. Medi, Learned Counsel for the respond number 6 is present. Yes.
This way. It's coming from,
Huh?
he's coming from code number 1. The King House.
Miss RM Das, RM Decca, Learned Counsel for the Standing Council. NC Hills Autonomous Council submits that she be granted further 2 weeks' time to complete her instructions and file an affidavit in the matter. So prayer accepted, registry to on a date to be fixed by it. Yes. No problem.
Yes, my lord, the respondent 7, my lord, there have been an interim order. There, my lord, construction, I have obtained a photograph, my lord.
Ms. RM Decca on the next date of listing shall also receive instructions with regard to the contention made by the Learned Counsel for the petitioner that the respondent number 7 herein
Has not taken any step, my lord, by responding. And to prevent it, my lord.
that the authority, the respondent authorities, more particularly respondent number 7, has been acting in violation of the interim directions passed by this court, wide order dated 28/3/2025. Also, interim order passed earlier to continue till the next date of listing. Get both. If that is so, you file a contempt, we'll consider. Mr. Soikia, very nice to see you.
Hello.
But the problem is there is nobody that side.
Simon substance is a case of double punishment.
How?
Because I was once punished. I was directed to pay deposit the money. I deposited. Then I was reinstated. Finding is given after inquiry that 5 persons were responsible for not collecting the money, for not recovering the money from the customer. So anyway, my share is given. And they being satisfied, they reinstated me and I was working. Then after the order being passed by the earlier board of director, the next managing director came and he altered the order of the earlier director. My lord, the full case is yes, my lord, 20.
What is the error in this page 30 or 31? Page 30 and 31.
Yes, ma'am.
You have accepted the penalty?
I have given the money.
Given the money. That means the charge has been accepted by you. So how will the period of suspension can be regularized like this?
Yes.
What is the error?
Nothing wrong with me, but that.
No, what is the error in page 30?
My lord, page 30, lordship. This order, they have, next managing director came, that the earlier order was wrong. Lordship kindly see.
Rightly so. This court finds this correct and you have been left out very leniently. You should have been subjected to bigger punishment.
No, lordship kindly see that actually actually, without proving any case, since they asked me that you pay the money.
That is enough.
Now, lots of kindly see page 21.
Okay.
Page, my lord,
Hmm.
19.
19, 19.
19. The report of the Dean of Inquiry conducted into departmental proceeding. Kindly see. The honorable members of the board are informed that a departmental proceeding was drawn up on 23/1/15 against the Bhupendra Goswami, then branch manager Swalkushi branch. 11 charges were leveled against the Goswami on dated 21/15 for the irregularities committed by FS Bank, ABS means not FS Bank small deposit at Swalkushi branch, pending department drawing of departmental proceedings. Sri Bhupendra Goswami, then branch manager Swalkushi branch, was placed under suspension.
We have
I-
got it, Mr. Sohit,
Then
we have got it.
kindly see.
Page
the find-
21,
find-
last paragraph.
Finding. Below person.
No, that page 21, last paragraph will do it.
Yes, Lordship. Page 21, last para, yes. Bearing is the responsibility amongst the bank staff as per the circular of bank was really good job, but it is observed that there was no proper coordination among them. So a part of the deposit of FS Bank small deposit accounts has been adversely affected. So in the long run, at the nature of such level against the above officials, similarly with the charges level against waiting, see Bhupendra Goswami, the then sponsor Swargaman, this civil proceeding is waiting for the outcome of the DP drawn against the Bhupendra Goswami manager for deciding the matter of punishment for the above employees as decided by earlier MDK and Talukdar, as informed by the BM Swarkushi Bans. So in the next column, see what's it, kindly see. Page 22. What's it? Below person. As none of the charges specifically proof, the board is direct requested to kindly decide on the matter based on the deemed of inquiry report as case is pending since long.
Hmm.
So none of the charges were proved. So the next order is important. Page 23, Lordship. So kindly see. The Perudi departmental proceedings done up against Sri Goswami, manager, Tezpur, so and so, that are so, along with statement of allegation of charges formulated under the said departmental proceedings and his written statement of defense. 11 specific charges were formulated against Sri Bhupendra Goswami for committing gross irregularities, misconduct, violation of rules and procedures, misuse of tasks, misuse of officials, so and so and so and so. Then now next part. A Geneva inquiry was ordered by the board in its meeting held on 29/7/17 and on 17/2/18, and on the request of the board of directors to the additional chief secretary cooperation department, station so and so had conducted the Geneva inquiry. The Geneva inquiry report was placed in the board of directors meeting held on 3/9/20. The board of directors perused the Geneva inquiry report as well as all facts related to the departmental proceedings. The House decided that all 5 employees of the Swalkushi branch, namely Sri Bhupendra Goswami, Sri Mihir Borua, Hemendra Kumar Talukdar, Sri Hari Prasad, Malaga and Sri Dinesh Das are responsible persons for irregularities in the Assam FS Bank small deposit accounts of Swalkushi branch. After detailed discussion, the House resolved the following. Resolution number 33, madam. The board held that 5 employees, namely Bhupendra Goswami, Mihir Kumar Borua, Hemendra Kumar Talukdar, Hari Prasad Malakaran, equally guilty of committing serious financial irregularities in respect of the accounts of Swalkushi bonds, and decided to inflict punishment by making recovery of the pecuniary loss suffered by the bank to the tune of rupees 26,19,820 lying in the suspension account of the bonds in equal share from each of the efforts employees, with a caution to them not to commit such nature of irregularity in future. The board, to dispose of the matter, accordingly directed the managing director to issue necessary orders to each of the employees separately. Now, lots of below person. Pursuant to the above decision, I see Sasanka Sagar Shasti, managing director of the Assam Cooperative Society, Apex Bank, do hereby convey the decision an order, Chief Condition, page 24, for recovery of the pecuniary loss suffered by the bank to the tune of 26 lakhs 19,820 unequal share of each of the aforesaid employees. Accordingly, Chief Bhupendra Goswami is required to pay rupees 5,23,940, being 1/5 share of the pecuniary loss. Now, Lordship, Chief Bhupendra Goswami is also concerned not to commit such type of nature of irregularities in future. Then next para, the permanent proceeding drawn up against Chief Bhupendra Goswami on Imani is disposed of, subject to recovery of rupees so and so. Chief Bhupendra Goswami manager recovery branch will be entitled for drawing full salary during his period of suspension along with the other benefits. And what happened in this case? There are in the bank, there are some agents. Agents are collecting the money from
That
the.
is different. You
no.
you were subjected to a
Condition.
department proceeding.
Ah.
The charge was held to be proved and you were supposed to have been involved in misappropriation of that amount along with others, and an amount of rupees something, 5 something was directed to be repaid.
I have paid.
You repaid.
Repaid.
Then there was an
But-
order issued.
But
In that issued, in the order
One-
was in pursuance to a resolution of the board held on 3/9/2020.
Yes.
So therein, there was nothing in the board's resolution with regard to the manner in which your suspension period will be regularized. The managing director proceeded on its own.
Oh, my lord, my prayer. There is no such provision that once a decision taken for to reinstate me, I was reinstated, I paid the money as an honest officer.
54B,
Just a minute,
FR 54B.
my lord, just a minute. When I have paid the money, the next managing director has altered his earlier decision. He has no
No,
longer.
he has not altered. He has placed the matter before the board. Board has the power.
No, my lord, kindly-
Board altered the matter.
no, earlier board took the decision and.
Board can review its own
but-
decision. Show
The
me
board- There is no
the.
provision under the law to review the order of the earlier board. Lordship, I have brought the judgment. Lordship, kindly see. Yes, sir. Tagore order. First, I will place this earlier order of the High Court once, because this petitioner once approached this court for because they impose a condition that you cannot go against the bank. And this is the order. 19/12/22. And Mr. B.C. Das, Garnet Senior Counsel for the petitioner, also hired Mrs. M.D. Bora. And Lordship kindly will see, Para 4. The petitioner is specially aggrieved by clause 4 of the aforesaid declaration cum undertaking format, which is extracted as below. That I hereby declare and undertake that the said matter has been settled between me and the bank in toto, and nothing whatsoever remains pending in this regard, and the matter has been resolved. That future I will declare that there is absolutely no matter of unresolved conflict between me and the bank on the date, and no grievance from my end against the bank in any matter, be it financial or otherwise. And further declare that nothing whatsoever shall entitle me to any right,
Soikya,
my lord.
this writ petition is prior to the writ petition involved in this order.
Yes.
So here, that is your, this order is not affecting your pension.
Look, once I am getting the salary with allowances, how again they can take a resolution that the earlier resolution.
That was
of
not
the board-
released to you.
No,
Then
Lordship-
what is the review decision?
Which is review, my lord, kindly.
No. The board cannot review its own order.
That let them show.
No. That is for you to show
No,
that.
no, my lord, that they are, who is the procedure under order 47, rule
No,
11.
no. This is
Now-
not, this is an administrative
No.
order.
It is a double punishment, kindly see. That's Article 20 may be kindly seen. Of the
We have
Constitution.
dealt with similar matters.
No, my lord. So
of this bank
the
only.
judgment I have brought, Lordship, for
What
a
was the
while.
name?
forever.
Recently,
Kindly see Article 20.
de novo inquiry, I found that they were not given that chance.
Article 20, no person accused of any offense shall be compelled to be, no person shall be prosecuted and punished for the same offense
Okay.
twice.
Okay.
Now, judgment I have brought.
No judgment is required.
It's necessary, not, Your Lordship, has the first experience, that is why I place it before Lordship. Lordship kindly see judgment of the Supreme Court. Paragraph 7. 7. Paragraph 7 may be seen, madam. Fundamental right which is guaranteed by Article 22 enunciates
Done.
principle of
Accepted.
kindly convict or double jeopardy. The root of the principle are to be found in the well-established rule of common law of England, that where a person has been convicted of an offence by a court or competent jurisdictions of conviction is a bar to all further criminal proceedings for the same offence. To the same effect is the ancient maxim, nemo bis debt punir pro anno delitio. That is to say that no one ought to be twice punished for one offence, or is sometimes written pro anno cause, that is for the same offence, same cause. So a person is guilty for an offence, he is punished, and again for the same offence, he cannot be punished. That's it. Now, Lordship, kindly see paragraph 9 of the judgment. Paragraph 9, Lordship. Principle found recognition section 26 of the General Clauses Act, where an act or omission constitutes an offence under 2 or more enactments, then the offender shall be liable to be prosecuted and punished under either or any of those enactments, but shall not be liable to be punished twice for the same offence. And also section 403 Criminal Procedure Code. A person who has been tried by a court of competent jurisdiction for an offence and convicted or acquitted of such offence shall, while such conviction or acquittal remain in force, not to be liable to be tried again for the same offence, or nor on the same facts for any other offence for which a different charge from one made against him might have been made under section 236, or for which he might have been convicted under section 237. The 5th amendment of the American Constitution so and so, nor shall any person be subject for the same offence to be twice put in jeopardy of life or limb, nor shall be compelled.
Mr. Seki, need not take the trouble. We have gone through it. We will refer to this. We will refer to this. We have gone through it. We have gone through it. Anything more?
My submission before Lordship. Now, your Lordship has to see that
You are here in the second half? 1 o'clock.
all that Lordship.
You make your submissions 5-10 minutes. We have 2-3 matters fixed up. Thereafter, we'll take this. Fix the details also. So you can come little bit late because we have fixed up matters. Some
I will
matters
go
fixed.
for a cup of tea, then I'll come in.
Aram se. Yes, Mr.
On request being made by him, I'm appearing for Lordship to apprise this court. Saturday night, someone away to Karimganj Minor. It's made by him, that's why I'm apprising this honorable court.
Death in a family.
For your Lordship, some similar issues, my lord, regarding challenging the 64A. It is pending on 27th.
Yeah, here the act is not under challenge. Followed in the manner required, that we have seen from the documents. See, Mr. Nath, I understand the urgency, but the problem is when a mention is made in this connection, so I am not in a position I should not be, because no, what we do is we fix it as the first item day after tomorrow, as per the prayer made, morning, first item, 10:30. Rekha, heard Mr.
FKR Ahmed.
FKR Ahmed, a learned counsel appearing on behalf of Mr. A.K. Talukdar. Mr. Ahmed submits that the Mr. Talukdar has requested him to make a mention in the matter today for an adjournment on the ground of personal inconvenience, on the ground that he is out of station. Also, Mr. D. Nath, learned senior government advocate, submits that there is extreme urgency in the matter inasmuch as the construction of the road, that is the expansion of the road from a 2-lane one to a 6-lane one, is required to be completed in a time-bound manner, as it has a relation to the operation of the activities. It has a connection with the Lokopriya Gopinath Bordoloi International Airport, now under now being readied for inauguration. 26th of December, November. Also, in the above view of the matter, Mr. Nath submits that the pleadings brought on record would reveal that the plea of the petitioners that the notice required under section 3(1) has not been issued is clearly not sustainable, inasmuch as the 3(1) of the Assam Land Requisition and Acquisition Act 1964 has not been issued is clearly not sustainable, inasmuch as the said notices were duly issued to all the patadas, including the petitioners herein, from whom the land in question were initially requisitioned. Also, Mr. Nath further submits that insofar as the petitioners herein are concerned, they had refused to accept the notice so issued, accept the order issued under section 3(1) of the Assam Land Requisition and Acquisition Act 1964. Also, Mr. Nath submits that the proceedings as required were so carried out strictly in accordance with the provision of the said Act of 1964 and thereafter, on issuing the notification under section (1) of the LA Act 1964, the land, the amount of compensation as payable to each of the patadas involved, including the petitioners here, were determined by the competent authority. Also, he submits that the notification under section 6(1) of the Act of 1964 was duly published in the official gazette. Was published in the official gazette, 6(1). 6(1). Also, he further submits that thereafter, in terms of the provisions of section 7(1), notices were issued to each of the petitioners herein for receiving their respective compensation, the compensation amount determined in respect of each one of them. Also, Mr. Nath also submits that the petitioners herein had not approached the authorities for receiving the payment involved. receiving the compensation amount so determined in their respective cases. Mr. Nath submits that around 700 people were involved in the proceedings of LA case number 12 and LA case number 13, right? Around a total? There are around 729 patadas involved in the proceedings of LA case number LA case number 13/2024, including the petitioner number, including the petitioners number 1 to 5, 7 to 20. So he submits that the other patadas involved, other than the said petitioners, have not raised any dispute with regard to the institution of the said LA case number 13/2024. Insofar as the petitioner number 6 is concerned, his land is involved in the proceedings, the land as acquired from him is involved in the proceedings of LA case number 12/2024, and therein there are other 183 patadas. Full stop. It is submitted that it is only because of the present petition, present proceedings pending before this court, and the order dated 19/12/2024 passed by this court, restraining the respondent authorities from carrying eviction of the writ petitioners without following the prescribed procedure under the relevant statute, the work in so far as the particular stretch is concerned is not in a position. The stretch wherein the lands of the petitioners are involved is not in a position to be taken forward. Also, Mr. Nath has further submitted that the order, interim order passed by this court, while the said order dated 19/12/2024 has not been extended after 18/8/2025. Full stop. In the above premises, he submits that in view of the urgency involved and the steps as demonstrated to have been taken by the respondents and noticed herein above, be permitted, the respondent authorities be permitted to take the work involved forward, so as to work involved forward in as much as it is in the public interest that the work involved be completed at the earliest. Also, noticing the above position, and also noticing that the work here is work involved herein is of public importance, the grievance raised by the petitioners also being noted to be permissible to be adjudicated by this court and or a forum as prescribed for the purpose, this court is of the considered view that the interim orders passed herein not being extended, to issue a clarification to the effect that the continuation of the work by the respondent authorities would not, that it would not be, that there is no restraint upon the respondent authorities to carry forward the work in question. Full stop. That'll do. That'll do. Full stop. The said observation made by this court is so made by appreciating the urgency expressed in the matter by the learned senior government advocate. Full stop. This court further provides that the said order is subject to further orders that would be passed in the present proceedings by this court upon the while disposing of the present matter. as this order has been passed in absence of Mr. A.K. Talukdar, this court directs the registry to list this matter again on 21/11/2025 as the first item at 10:30 a.m. Let it be on 21. Let us hear him what he has to say. You depute somebody. Mr. Borpujari would be there. Upor Likhiba heard April Likhilana heard Mr. So and so Mr. D. Nath, learned senior government advocate, as well as Mr. R. Borpujari, learned standing counsel, revenue and disaster management department for their respective respondents. No, not before this court. Not raised a dispute in the matter before this court delivered.
Wait, please, your lordship, my lord. Wants to file one reply. What happened, my lord? Yesterday, only in the evening, I have received this copy, my lord. I have forwarded to the petitioner.
Why in the evening? Which is the affidavit?
Yesterday, they have filed, the chief engineer.
Oh, we are ignoring that. We are ignoring that.
Yes, yes.
We are ignoring that. Don't worry. No, we are ignoring that.
On Friday, my lord. Let this come up on Friday, my lord. Let this matter even part hard, my lord. Remain as part hard, my lord. Friday, my lord.
See, it will be a useless formality.
What happened?
Nothing is going to happen.
In paragraph 10, my lord,
Hmm.
they have stated, this chief engineer has stated one fact that this wanted her own request to transfer to the office of the executive engineer.
We are not concerned with that. We are concerned with the
So why-
order here.
Why this
We are
request was-
concerned with the order, Mr. Goswami. The order is on record. If
Yes.
you can take that order at page 33, this order was passed in 2005, never put to challenge. You have annexed it in your writ petition. Forget the affidavit.
No, my lord, it's a last chance, my lord. Let this
No,
come on Friday.
No. We are ignoring para 10. But what have you got to say about page 33? Mr. I understand your problem, but appreciate this side also. When this court finds that this order is there
No.
from 2005 and you have done nothing,
What happened, my lord? This paragraph 10 has not clearly position because, my lord, under compelling circumstances, the petitioner wanted this transfer.
that is in 2005.
Yes, yes.
This order was with you. I understand that this order at page, where is that?
But in the year 2006, my lord, the executive engineer passed that order in my favor.
We'll consider that also. We'll consider the effect there.
Secondly, my lord,
We'll consider
whatever-
that effect also.
the Honorable High Court's order, the chief engineer was also party. The chief engineer was also party, the executive engineer was party.
Page 33. This order you had with you earlier.
Still, my lord, spending, your lordship, kindly give me some time.
Mr. R.
On
Goswami,
Friday.
learned counsel for the respondent, submits that, petitioner submits that he be granted a day's time to file a rejoinder to the affidavit filed by the respondent number 10. A registry to list this matter again on 20 at 2 p.m. 20
yes.
at 2 p.m. No further adjournment shall be granted in the matter for filing of the said affidavit. Why have you brought in that affidavit, Mr. What big thing have you stated there? But do you clarify?
Yes, my lord. And if necessary, my lord, I may challenge at this stage also. Your lordship will decide.
You withdraw this, I'm giving you the liberty. Subject to limitation, I'm giving you the liberty.
My lord, in the same writ petition, let it be continue. Conclude. Because, my lord,
Will not permit you to challenge an order of 2005 today.
why happened? My lord, there's a reason in 2006.
That was a reason which was there from 2005 itself. You have never
So
raised.
in 2006, this order in my favor, passed by the executive engineer, after the High Court's order, the Honorable High Court directed the executive engineer, chief engineer, and the state of Assam.
Show me the executive engineer has passed this order with the
It is
consent.
their
of
authority, my lord.
no,
They knows how to,
approval of the, because they have denied that.
no. The chief
Ah.
engineer,
Okay,
was a party.
we'll see on Thursday at 2 p.m.
Obliged, my lord. The chief engineer was a party, my lord. Obliged.
A senior arguments have already been heard.
No, we have passed this order. We have passed yesterday also. We'll finish it today. Okay. But the concerned steno will come the next time. We'll pass the order then. Mr. Bora was appearing. No, that is the matter. No, we don't require you. When the concerned steno comes, we'll pass the order. Gole, Protibak pathai dibi. Yes.
It was suspended on 10/5/2024.
That suspension. Lekha. Heard Mr. S. Nawaz, Learned Counsel for the petitioner. Also heard Ms. M. Bachchaji, Learned Counsel, appearing for the state respondents. Additional senior government advocate appearing for the state respondent. The challenge in the present proceeding is to an order dated 10/5/2024, placing the petitioner under suspension. 10/5/2024 issued by the Director of Sports and Youth Welfare, placing the petitioner under suspension. So, the facts in brief requisite for adjudication of the issue arising in the present writ petition is noticed as under. The petitioner herein, while working as
Instructor, my lord. Para 2, my lord, page 5.
was working as a physical instructor in the establishment of the district sports officer, Dibrugarh, comma. Oh, no. The petitioner herein was initially appointed as a physical instructor in the Department of Youth, Sports and Youth Welfare, comma, and was posted in the establishment of the District Sports Office at Tinsukia with effect from 1/1/2015. So, he was in the year 2016 transferred to the establishment of the District Sports Office at Dibrugarh, and was thereafter in the year 2019 attached to the office of the Director of Sports and Youth Welfare, comma, Assam. So, while continuing under such attachment, comma, on 6/4/2024, an FIR came to be lodged against the petitioner before the police of the Dispur police station by inter alia, alleging therein that the petitioner had forged the signature of the informant and had issued false appointment letters and other official letters to different individuals. So, the said FIR was registered as Dispur Police Station Case 307/2024 under Section 170/420/468/471 IPC. Also, on the registration of the said FIR, a show cause notice dated 12/4/2024 was served upon the petitioner through the WhatsApp Messenger app. Also, the petitioner responded to the said show cause notice by way of filing a reply dated 18/4/2024. Also, not being satisfied with the reply as given by the petitioner herein, comma, the Director of Sports and Youth Welfare Assam proceeded wide order dated 10/5/2024 to place the petitioner under suspension. It is projected that the said order of suspension was again served upon the petitioner through the WhatsApp Messenger app. Also, After the said developments had taken place in the matter, a further FIR came to be lodged against the petitioner on 19/7/2024 before the police of Dibrugarh Police Station, which was registered as Dibrugarh PS case number 279/2024 under section 406 IPC. FOSUP. The petitioner came to be placed under detention in connection with the said case on 14/9/2024. FOSUP. The petitioner was enlarged on bail on 14/10/2024 by the Court of the Learned Chief Judicial Magistrate, Dibrugarh. The petitioner was also shown arrested in connection with Dispur PS case number 307/2024. And so the petitioner was granted bail in connection with Dispur BS case number 307/2024 on 30/11/2024 by the Learned Special Magistrate, Kamrup. So the petitioner, on being released on bail, submitted a representation on 13/12/2024 before the Director of Sex, Sports and Youth Welfare, Assam, seeking reinstatement in his service. Also, the said application and the reminders preferred thereto not having evoked a response from the respondent authorities, the petitioner has instituted the present petition. Also, the Learned Counsel for the parties and peruse the materials available on record. The facts as noticed herein above is not in dispute. The petitioner was placed under suspension with effect from
Page 31.
Under suspension under the by invoking the provisions of Section 6(1) of the Assam Services (Discipline and Appeal) over Rules 1964 by the order dated 10/5/2024. Also, on a query made to the Learned Counsel for the parties, this court was apprised that after the petitioner was placed under suspension, no departmental proceedings was instituted against him in the matter till date. First of, the disciplinary proceeding have been instituted. When?
That, my lord, no memorandum not been called for any departmental proceeding. In fact, Lordship will kindly see page 49. Asked to produce a copy of and gave a copy of the bill.
Okay, where is the show cause that was issued to you?
Show cause, my lord, was in first show cause notice was on, my lord, page 27, my lord.
What is this proceeding, miss? Some sort of a semblance you must have. Come to page 27. If they don't know, they don't know how to do a proceeding, better they don't do all this thing. Constitute a different cell for that purpose. What is this notice? Read it. You are hereby required to show cause under Rule 6, read with Article 311 as to why disciplinary proceeding should not be initiated against you for the following reason. What is this? This is height. He is not a person fit to be retained. Do it in the manner required. Score of Quran. I'll pass the order. We are reinstating him. But Rule 21, and I'll make an observation that the proceedings are not the proceedings which is mandated to be drawn. Madam, who prevented you from not reckoning that gravity in the manner required? The provisions of rules we cannot. He does not know that a proceeding is instituted against him. And if I have to make all those observations, it will go against the officer concerned. I'll pass the order. This Court of Quid, am I reading it?
And from service, Lord, the petitioners are before your lordship.
Yes,
the home
what
clerks.
is your instruction?
Ask question that, order, my lord, to apprise the court.
Yes, Miss Madam. Why not? If I can give it after some time this side, I'll have to give this side also. After some time. Yes, Mr. Bhathagur.
Their own committee constituted by the finance department, your lordship, is to be restored. Act, your lordship, honor. After your lordship, they left the matter to the administrative department consulted with the finance ministry. Finance constituted a committee of 2 of their officers. They recommended, your lordship. Thereafter, administrative department also, your lordship. Then, your lordship, they have come up with a plea that, your lordship, it may open floodgate. That cannot be a ground, your lordship, because, your lordship, someone will have to raise the anomaly, your lordship. That has not been raised by others, your lordship. Only we have raised it, your lordship. And anomaly, your lordship, was specific to us, your lordship. Precisely the case, your lordship. Your lordship will kindly see, your lordship.
Rate pay increase you want? Yes. DD. Who is there?
Next pay commission.
That is
So ultimately, your lordship, the base will be this, your lordship. That's
naturally. Before that, we'll have to decide this. When will Mr. Gugoi be available? Okay, we have too much.
Thursday, your lordship.
Tuesday. A prayer is heard Mr. S. Bhathakur, learned counsel for the petition, and Mr. A. Fukon, learned standing counsel, GAD. Pusa. A prayer is made on behalf of Mr. B. Gogoi, learned standing counsel, learned additional advocate general appearing for the finance department for an adjournment in the matter on the ground that he had to leave the court on account of certain personal difficulty, personal inconvenience. Also, in view of the above position, a registry to list, it is stated at the bar that the pleadings in the matter is complete and the matter can be taken up for final disposal. As agreed to by the learned counsel for the parties, a registry to list this matter on 25 or 27, which is 25/11/2025.
If you oblige.
registry to list this matter before any other bench without me. No, next matter.
Hello.
You have got something? Both are equal. Madam. Gone. Heard Ms. D. Ghosh, Learned Counsel for the petitioner, also heard Mr. P.K. Munir, Learned Counsel, appearing for the respondents. The petitioner, by way of instituting the present proceeding, has prayed for a direction upon the respondent authorities to grant retrospective promotion to the petitioner to the posts of development officer and district officer with effect from the date he had assumed charge of the same. He had officiated against the same. Also, the petitioner has also prayed for a revision of the pensionary benefits received by the petitioner upon grant of retrospective promotion to the development officer, grant of retrospective promotion to development officer and district officer. To retrospective promotion to the development officer and district officer with consequential benefits. The facts in brief requested for D. Ghosh sir. Requisite for consideration of the case of the issues arising in the petitioner, while working as a manager of Village Oil Industries under the Assam Khadi and Village Industries Board, bracket hereinafter referred to as the board, was promoted to the post of Inspector of Village Oil Industry by an order dated 25/1/1995. Full stop. The petitioner, while discharging his duties as an inspector of Village Oil Industry, was by order dated 23/12/2002, directed to officiate against the post of development officer of the board. Also, the order, while asking the order dated 23/12/2002, while allowing the petitioner to hold the charge of the post of development officer, it was stipulated that he would continue to draw his pay and allowances in the scale authorized to him against the post of Inspector of Oil Industries. Full stop. The said order dated 23/12/2002 was further partially modified by an order dated 1/2/2003, and the petitioner was now allowed to officiate as a development officer. Full stop. Subpara. The petitioner thereafter was by order dated 6/8/2004 transferred and posted as in charge district officer in addition to his present district officer Kamrup in addition to his present duties. The petitioner accordingly complied with the said order of transfer and joined as and assumed charge as the assumed charge of the post of district officer Kamrup on 9/8/2004 on in charge basis. Also, the petitioner was also by order dated 20/2/2007 required to take over charge of the post of district officer, Dorong District Office, on the incumbent therein proceeding on incumbent therein vacating the post on reaching the age of superannuation. Also, the petitioner having been subjected to ad hoc arrangements in respect of holding charges of higher posts, comma, and he being not promoted to the post charge of which he was holding, comma, led the petitioner to institute a writ petition being WPC number 6161/2013 before this court. So this court, while order dated 28/10/2030, proceeded to dispose of the said writ petition, granting liberty to the petitioner to approach the respondent board by way of filing an appropriate representation agitating his grievance. The said representation was directed to be disposed of by taking note of all attending facts and circumstances and in accordance with law. So the petitioner thereafter prepared a representation on 5/11/2013. So the petitioner herein on reaching the age of superannuation. When did you retire?
31st/12/2014.
13.
14, Lordship.
Thereafter, the petitioner, by order dated 10/3/2014, was promoted, comma, on his selection, comma, to the post of district officer in the scale of the district officer. So the said order was the promotion of the petitioner was effected with a retrospective effect, that is, with effect from 17/7/2013. Also, the petitioner, while functioning as the the petitioner after his promotion to the post of district officer, comma, retired from his services on reaching the age of superannuation with effect from
31st, Lordship, 31st/12/2014.
31/12/2014. Also, the petitioner thereafter instituted the present proceedings before this court on 20/12/2014, praying for the reliefs as noticed herein above. Also, I have heard the learned counsel for the parties and also perused the materials available on record. The projection made in the writ petition would reveal that the hierarchy of the posts available in the board is as follows. Inspector of Inspector of Village Oil Industry, Arrow Diba, Duta. Development Officer, followed Diba, District Officer. Accordingly, the petitioner had projected that he, having held the charge of the posts higher in hierarchy to that of the industry inspector of village oil industry, and he being eligible for being promoted to the higher posts of development officer and district officer, comma, the non-consideration of his case for promotion to the post of development officer with effect from the date he was allowed to officiate against the same, comma, a vacancy admittedly being available, comma, had caused severe prejudice to the service interest of the petitioner herein. The petitioner submits that he, having held the charge of the post of district officer with effect from 6/8 in pursuance to the order dated 6/8/2004, comma, the promotion of the petitioner to the post of district officer as affected by order dated 10/3/2014, having granted a retrospective effect to such promotion only with effect from 17/7/2013, the petitioners has suffered a prejudice and the said promotion ought to have related back to the date when the petitioner was allowed to take charge of the said post in pursuance to the order dated 6/8/2004, a vacancy admittedly being available. So, at the outset, this court notices that the the order dated 10/3/2014, promoting the petitioner herein to the post of district officer with effect from 17/7/2013 is not under challenge in the present proceedings, and the same has attained its finality. However, considering the fact that the petitioner, while being promoted from the substantive post of inspector BOI to that of the post of district officer, without considering his case for promotion to the post of development officer, this court had required the parties to the proceeding to apprise this court as to the hierarchy maintained with regard to the promotional avenues for an incumbent in the cadre of inspector, village oil industries, in the board. Also, in response to the said query, Mr. P.K. Munir, learned counsel appearing for the respondent board, has placed on record a communication dated 18/11/2025 received by him from the register Assam Khadi Village Industries Board, wherein it has been reflected that the posts of development officer and district officer are equivalent. Also, it is also noted that the pay scale for the post of development officer and the district officer is one and the same, that is rupees 8,000-35,000 with grade pay of rupees 4,500 in terms of the revision of pay rules 2010. Also, the above being the position and the petitioner having already been promoted to the post of district officer by issuance of the order dated 10/3/2014, there would arise no occasion for a direction upon the respondent authorities to again promote the petitioner to an equivalent post of development officer. The petitioner has also not demonstrated before this court in the present proceeding about the hierarchy maintained in the department and also amended in the department. This court, on a perusal of the order dated 10/3/2014, finds that the petitioner was promoted to the post of district officer from his substantive post of inspector, village oil industry. Further, the equivalence as highlighted by Mr. P.K. Munir, on instructions received, is also discernible from the order dated 6/8/2004, by which the petitioner was transferred and posted from the post of development officer officiating to that of the post of district officer Kamrup. The said transfer also highlights the equivalence between the said two posts.
Was only promoted because I was inspector. I was officiating as development officer and
Then transferred.
a transfer and officiating as district officer. I was not promoted to district officer.
So you were promoted subsequently.
Subsequently, by order dated 10/3/2000.
That is what I said. That is what I said. I said that
But I was when I was promoted, I was inspector only.
you have been promoted from inspector to district officer.
Yes.
That shows that is hierarchy. Further, development officer to a Kamrup district officer, you have not been asked to take charge of a higher post. You have been transferred. So that again brings pulls up. The petitioner in the present proceedings, having already retired from his services with effect from 30/12/2024, the prayer of the petitioner for being granted retrospective effect to the promotion already granted to her to the post of district officer while the order dated 10/3/2024 would not mandate an acceptance inasmuch as the petitioner at present would not be in a position to assume the charge of the post of post of district officer or development officer with effect from the date to which such retrospective of promotion would now relate back to. Refer the Supreme decision of the Honorable Supreme Court in the case of Dr. Amal Sattapati versus Madhyas Vakil. Yeah? Full stop. In view of the above discussion, this court is of the considered view that the petitioner already having been promoted to the equivalent post of district officer, there would arise no further occasion for directing the petitioner, case of the petitioner to be promoted, to be considered for promotion to the post of development officer from a date prior to 17/7/2013. Accordingly, this court is of the considered view that the present writ petition is devoid of any merit and the same consequently stands dismissed. However, there would be no order as first. I had worked out something that development part. Can't help it.
He retired on 1st of March 2004.
To Jojo 30/12/2014 as Sorry, next time.
Deeply obliged.
Mr. Munir, you get hold of him. He has destroyed people. This thing you can have given me long back, this much. I was against her. Then she started arguing. I changed my view. We are all chameleons. We change now. Then that day, I was adamant that no, you will have to promote her as development officer also. How? Skipping one post is earlier there was, you were in class 3, they promoted you to class 5. Double promotion. So double promotion here in service law, it's not maintainable. So you will have to take her to development. The benefit is if she becomes a development officer, she gets a better higher scale. Then the fixation in the district officer's post would be at a higher level. Pensionary benefits would be. So I had made up a mind that we will give her the pensionary benefits. That pay we will not, but the notional thing, she gets something. She would have got a handsome, something better. But now you have demolished everything, Ms. Ghosh. So be careful when you go out. Yes, where is the records? Okay. On the prayer of the Lanka Council for the parties registry to list this matter again on 27. 27/11, huh? Second time, Machu, no? Okay. But where is the petitioner? None appears for the petitioner even on second call. Accordingly, the present writ petition stands dismissed for non-prosecution. Even on second call, huh? Dismiss no koriba. However, for the ends of justice, registry to list this matter again on 3/12/2025. Good day. Yes. Show me.
I have got some two.
Please. What were you there? No. What was he working as? Operator.
Firefighter, my lord.
not officer. Yes,
There are three lordship machine.
of which one?
1991
Here the Assam Petroleum Limited is managed by the government of Assam.
No, my lord. It is under the All India Limited, my lord.
Oil India has a share.
Yes, my lord. But the All India Limited, my lord.
Show me. Forget these judgments. You show me first you show me the foundation, then we'll go to judgment. No, forget it. Now, Mr. Sinha, show me that this Assam Petroleum Limited is a organization under the deep and pervasive control of the Indian Oil Corporation. It's an arm of the Indian Oil Corporation. Where?
It's not there, my lord.
Then who holds the shareholding of this company? Private? Huh?
All India Limited and Government of Assam
Huh?
Limited, my lord.
Show me.
Not there in the, my lord.
Just show me that we will hear the matter on merits. Forget the name. My name also there is something. I'm not God. Am I God? But my name has God, name of God in it. Yes. Mr. Sinha, no further time. You tell me.
Private Limited company, my lord.
Huh? Private limited company.
Yes, my lord. The various oil field working and activities, including the operation and dealing of assets.
That they are contractors, they can do anything.
That is contract, my lord. That is contract.
But where is you withdraw this, I'm giving liberty to approach the Mr. B. Sinha, heard Mr. B. Sinha, learned counsel for the petitioner. Also heard Mr. R. Hazarika, learned counsel for the respond number 1. And Mr. S.K. Chakraborty, learned counsel appearing for the respond number 3. 1 and 2. And Mr. S.K. Chakraborty, learned counsel appearing for the respond number 3. Mr. Sinha, Mr. R. Hazarika had raised an issue with regard to the maintainability of the present writ petition. Also, Mr. B.P. Sinha, learned counsel for the petition after attempting to argue the matter at some length and being unable and being not in a position to demonstrate that a writ would be maintainable against the respondent number 1 company, submits that he be permitted to withdraw the present writ petition with liberty to the petitioners to approach the appropriate forum for a redressal of their grievances. Also, prayer is not objected to by the learned counsel for the respondents. In view of the above, the present writ petition stands closed with liberty to the petitioners to approach the appropriate forum for a redressal of their respective grievances. Full stop. Dismiss for default, dismiss on withdrawal. In view of the above, the writ petition stands dismissed on withdrawal with a liberty to the petitioners to approach the appropriate forum for a redressal of their grievances. Error did you? In an appropriate case, this will come to your help. Yes.
Lord, now,
We'll hear Mr. Goswami also a little bit, otherwise Mr. Goswami will feel I am only hearing Mr. Soikia, I am not hearing him.
my lord,
Mr. Soikia has placed his case. Now it's for you to answer. Answer. Mr. Soikia, please take your seat. We'll hear you in reply. Yes. Have you understood the arguments of Mr. Soikia? 2-point argument. 1, I had done what you had asked me to do, paid the amount. And the consequential order that was passed had also regularized my period of suspension. How could you have taken a contra view, which amounts to a review, without a power being conferred? Oh, that's what Mr. Soikia is. You had taken a resolution earlier, that is resolution number 33. Now this resolution number 2B, being in review of that, where is the power? Hmm. Which one? This order? Where? Oh, that is true.
That order is that resolution. That was
Forget
not-
it. That need not be. Is that your argument? If that is your argument, we are dismissing. We are rejecting that. He is not expected to challenge that also. He is challenging the consolidated order by which he is being imposed with this. Forget it. It merges with this order. We'll not accept that. Tell me why this order is, you have heard him, no review. This is a second show cause notice. 109 is a second show cause notice. Huh. Okay, we have read it. What is your submission? That is the only thing I wanted to hear from you. Now, yes, Mr. Sagar. See, there was a resolution. That resolution did not say that your period, they said that impose penalty, 33. The managing director, maybe for many reasons, we don't know, while directing you to repay the amount, also regularized your period of suspension as on duty, which he could not have done. The matter came up before the board in the form of a compliance report. The board, on finding that the resolution was not implemented in the manner it was to be implemented, directed that no, this cannot be. Then took a decision to that part. It did not impose any penalty on you, only the period how it should be regularized.
Board, in my writ petition, I have annexed, but for just a while. On page 23, board, my lord, held, the board was held, and the board, my lord, has taken the decision at page 24. There were total.
No, the board did not,
It was the board,
did not take the decision.
My lord, kindly see page 23.
Down below.
Resolution, middle portion, lordship, my lord. Resolution number 33. The board held the 5 employees, namely so and so and so. 5 employees, lordship.
This was only to the extent of
Yes,
recovery.
recovery.
It
And-
did not deal with the manner in which the suspension period would be dealt.
Recovery itself is a punishment because, yes, my lord, I have brought the book.
Yes, it's a punishment.
Yes, my lord, discipline proceeding under the Assam Discipline Rules, Rule 9, that a person is found guilty or responsible, one punishment that is
No
that the
state
whole.
FRSR to
My lord, kindly see. the rule.
No, we have got it, Mr. Saikia. Don't take the trouble. It's a penalty.
Kindly see.
It's a penalty.
My lord, see the discipline, Assam Discipline Rules, Rule 9. So the proceeding done under this rule.
Maybe sub-central. Yes, Rule 9.
Yes, Rule 9, 7, recovery from pay. A disciplinary authority can recover from the pay of an officer who has been responsible for any pecuniary loss, not only to the state government, but also the central government or any other state government or any other local authority to whom the services of the officer had been lent. The disciplinary authority can recover either the entire amount of the pecuniary loss or a part of that. In deciding the degree of officer's pecuniary liability, it will be necessary not only to look into the circumstances of the case, but also to the financial circumstances of the officer, since it is recognized that pecuniary penalty should not be such as to impair the government servant's future efficiency. The disciplinary authority will specifically mention in the order the following details regarding the recovery. The amount to be recovered by deduction from the monthly pay, bill or of the officer, the period during which the recovery will continue, and whether the amount so recovered represents the whole or part of the penalty of the pecuniary loss. Now, they have recovered that 5 lakhs rupees from each of us. There were 4 persons. Other persons are given full allowances. I have made this statement in my written statement. Other 4 persons, including me,
Where the branch manager?
they have been.
Where the branch manager?
No, not only that question of branch manager and the Shimala. 4 persons.
I know, I've seen it.
4 persons, Lordship condition. There is no question of branch manager, no, my lord, or a
All are equally
or
responsible.
equally under Article 14. Lordship kindly see. My learned friend has mentioned to page number 109. Here themselves they have admitted there were 4 persons and 4 persons were equally responsible and money was recovered. Then why my suspension period should not be given? They have given suspension period, they have got. And when the first board of director has held that you are reinstated in service. Once my lord, a servant is reinstated. My lord, once a man is reinstated, there is no scope again that he will be again inflicted punishment.
What has happened here is 54 FR 54B.
My lord.
So once a penalty is imposed, departmental proceeding is drawn up, penalty is imposed. Along with that, if he is under suspension earlier, that period is also required to be regularized.
Yes, they have my lord, by order of reinstatement means it. When I am reinstated in service, it means the other agenda has gone. When the order on the first order, lordship, now number 1. Number 2, my lord, lordship, when the other 4 persons, have not, their allowances have not been deducted. Why? Is it not, my lord, does it not violate the rule 14, equality before law? We were 4 points of the ban. And now, lordship, one important point is that these 4 persons, when they were in service, full salary was given, allowances was not deducted, suspension period was not deducted. Then, in the meantime, a police case they have filed against the agents. Agents admitted that yes, we took the money, we did not deposit the money. That they did not bring in their departmental proceedings. Lordship, I have brought the points. This may kindly be called for from them that the other agents, Lordship, kindly.
Now, how can I examine that?
No, my lord, no.
Because you are not against the penalty.
The kindly see paragraph of my important points, some important points I have got from my.
Okay.
Paragraph 3. Two events clearly stated in the local daily newspaper as well as before the management in writing that they have committed the misappropriation and they are liable to recover the money. Relieving the actual culprits, the management has penalized the nearby staff. Now we are 4 persons. If you again by subsequent order, you modify the earlier order, you cancel the earlier order, then other 3 persons should be also equally punished. Number 1. Number 2, my lord, I have gone. I have once this case was heard by before another bench. Surana, Justice Surana asked them, should the rule that you can again punish them. Rule. They failed to provide the rule.
I have asked him, he has failed again.
Let them see the rule. Let the
I have asked him, he has failed.
Rule.
Oh, that's it. I have asked him the rule for power of review.
Let them.
Mr. Goswami has miserably failed.
My lord. Now if your lordship, whether a man can be for the same offense can be convicted twice, because on that day honorable judge held that you cannot convict twice. Show me the rule. Now I have brought that judgment that I have placed before lordship, that a man cannot be convicted twice. I can be, if I am punished 10 years rigorous imprisonment, order is passed. Again by another order, the same authority cannot say you should be hanged. Either I should be hanged or I should be sent to the jail 10 years. One punishment, my lord. A man committing a crime should
Cannot
be
have
punished.
two.
Not twice. So my lord, your lordship has gone so many cases. While your lordship is with us, your lordship has gone
I'm
many.
still with you, Mr. Swigert. I'm still with you.
No, lordship was, while your lordship was in the bar, you lordship argued, I have seen such type of cases lordship has argued that a man committing a crime once punished, again second punishment. A man is hanged.
That is the love of Mr. Soikia towards me.
I have my great love for you as my younger brother. I openly in the bar in meetings, I declare that now my friend.
I'll consider. Heard Mr. R.C. Soikia, Learned Senior Counsel, assisted by, who you are assisted by?
M. Kolita.
I just wanted to know who, 3 are there, who is assisted?
Yes.
Mr. M. Kolita, Learned Counsel for the petitioner. Also heard Mr. J.K. Goswami, learned standing counsel, learned standing counsel, Assam Cooperative Apex Bank Limited. Hearing concluded, judgment reserved.
Man is already retired, madam.
Huh?
The old man. But Justice Sagla,
For delivery of orders, Biraspati
that's a sentence I am blessing your lordship. I have gone few days back in our chamber. There was discussion that MC Sagla, the famous judge, in his book has held that justice now does not only mean the law, it should be of somewhat of merchiness also. So a retired man-
Justice should not be done, it should be seen to be done. We are aware, so thank you for reiterating
So
that.
my humble prayer, my lord, let this old man go with it because others are getting the same benefit. Benefits are given by the bank. Why for this other, for this man only, another punishment is given.
Okay, you are here for a very small part of the thing, but Soikia is appearing, I should be also prepared. So I had gone through the whole thing.
Hello.
Tentative view is that you have been let off very cheaply.
Because I try my best to for the justice actually, for the justice.
That's why we came prepared. When
Hello.
Mr. Soikia is appearing, I can't take liberties.
Obliged, my lord.
I'll have to be.
Obliged, lordship.
Thank you. We'll pass the order. Kundina addition. 20 तारीख है टीरिया. लो लो बेटा मोटा हमारी डीलिंग.
Yes, your lordship.
On the prayer of the learned counsel for the parties, registry to list this matter again after registry to list this matter again on 27 11/2025. Sorry, madam, I fixed up many matters. Not be possible. They are also humans. Me, I'll dictate on, but they are also humans, and then the problem will come to me for correction. So I'll have to be very careful. 25. Okay, 25. 25. That much I can give you.
Going on for 2 years, my lord. And I'm very surprised, my lord, such kind of submission notice. No notice, nothing else. That is my main ground, my lord, in the writ petition. No, these are poor petitioners, my lord, they are suffering. That's why, my lord, I am.
This submission is coming from a person in authority, through a person in authority.
This matter is at a hearing stage, my lord.
Okay. Just
That
hear
should
what
not be
I'm
allowed.
You just hear what I'm saying. Heard Mr. H. Gupta, learned counsel for the petitioner. Also heard Ms. M. Bachaji, learned additional senior government advocate, appearing for the state respondents. This court had wide order dated 16/10/2025 required the learned government advocate to receive instructions with regard to the stage at which the proceedings instituted against the petitioners for indisciplined conduct was pending. Today, Ms. M. Bachaji, learned counsel for the petitioner, has, on instructions received from the madam?
District Command.
No, received from whom? From the district commandant, Panikheti. Panikheti has submitted that the notices were already issued to the petitioners. However, they have not appeared for the conduct of the inquiry, and accordingly, the matter is pending. On the next date of listing, the District Officer Paniketi shall, in writing, submit a report before this court with regard to the steps taken along with its dates against the petitioners for their purported indisciplined conduct, along with the copies of the notices issued to them and the manner in which it was issued, and as to whether the said copies were actually served upon the petitioners. Also, in the event the said notices were not served, the said report shall also contain the steps thereafter taken in the matter. The said report be placed before this court on 28. Mr. Now let it come. If that is there, that is there. If that is not there, if we find that you got the notice, somebody came to serve
After
it.
2-3 hearings, my lord, they are making
Oh,
submission of notice.
okay, if they have come to you,
Basic stand.
I have said if you have refused, because we get in day and out these matters. The petitioner comes and says, I have not received notice. The respondents bring
They
the
have already
notice.
filed affidavit earlier, my lord. Now they have said-
Wait for a day. What? Your friend has something, put it to the court, otherwise he might feel bad.
My lord, trying to say, my lord, by way of an affidavit, they have informed that inquiry is undergoing, but they have not disclosed.
That is why I have now passed this order. Now, we'll bind them up. If they have it, they have it. If they don't have it, they don't have it. I have, I think, taken care of all the situations. Let them come on 28/11/2025. In the event the said report is not furnished to the learned additional senior government advocate appearing in the matter, concerned District Commander Paniketi shall personally appear before this court at 10:30 a.m. along with the contemporaneous records to assist this court in disposal of the present matter.
This order available.
No, it will be uploaded. You can download it. Ms. M. Bhachaji, learned additional senior government advocate, shall communicate the said order to the district commander. Commander or commandant? Commandant. Paniketi. The commandant of what is what? Manigine upload koi divide. Yeah.
24.
Hey. Table receipt. Five 5900. 5900. Also, the facts as noticed herein above is not in dispute. Also, the petitioners herein had applied in pursuance to a recruitment process initiated wide the issuance of the said advertisement dated 10/12/2021 for the post of dental technician, dresser, and dietitian. The qualifications are set out in the said advertisement for the said posts being relevant is extracted herein below. It to means Papa. A. Dental technician. Minimum requisite qualification. Page 31, A to A. R short, dresser, B dresser. A to B to B. Page 32. Or dietitian. C to C. Also, as per the projections made by the petitioners in the present writ petition, The petitioners number 1, 2, 4, and 5 who had submitted their candidature for recruitment against the post of dental technician, where only BS where had the qualification of BSc, Bachelor in Science, and the qualification of Bachelor in Science. Also, at the outset, full stop. The petition, this court would consider the case of the petitioners number 1, 2, 4, and 5 who had appeared for the who had submitted their respective candidature for the post of for recruitment to the post of dental technician. As per the own showing, as per the own projection made by the petitioners in the present writ petition, comma, the petitioners only had a BSc qualification. The advertisement had having specified the requirement of possession by the candidate concerned of a HSLC bracket science or equivalent qualification with 2 years diploma in dental technician course from a government recognized institute, comma, it is found that the petitioners number 1, 2, 4, and 5 did not satisfy the said requirement. Accordingly, the petitioners were so recruited, so appointed in pursuance to the selection held without having the requisite qualification as set out in the said advertisement dated 10/12/2021. No? Next, insofar as the petitioner number 6 is petition number 3 is concerned, comma, he had offered his candidature against the post of dresser. Also, the qualification as prescribed in the advertisement, that is HSLC bracket science with diploma in physician assistant course / OT technician course, was possessed by the petitioner herein, petition number 3. However, the respondent authorities found that the petitioner had pursued his diploma in OT technology from an institution not recognized by the government. So, the diploma as pursued by the petitioner not being pursued from an institution recognized by the government, comma, the said qualification would be invalid and the same cannot be used by the petitioner for the purpose of recruitment to the post of dresser in pursuance to the said advertisement dated 10/12/2021. Accordingly, it is to be held that the petitioner number 3 also did not satisfy the requirements with regard to qualification, educational qualification as set out in the advertisement dated 10/12/2021 for the post of dresser. Also, next, the petitioner number 6 had submitted her candidature for the post of dietitian, and she had a qualification, and admittedly she had a qualification of graduate in home science. The advertisement dated 10/12/2021 with regard to the post of home science had mandated possession by the candidate concerned of a qualification or of a graduate degree in home science or equivalent with human nutrition and dietetics, DIETETICS, as a part of the set curriculum. The petitioner, although had passed BA in home science, the course curriculum pursued by her for the said degree program did not have apostrophe human nutrition and dietetics as one of its subjects. Accordingly, the petitioner number 3 cannot be held to have satisfied the mandated qualifications for respondent number 6 cannot be held to have satisfied the educational qualifications spelled out for the post of dietitian in the advertisement in question. The above discussion would reveal that none of the petitioners herein had possessed the requisite qualification as mandated for the post against which they were so selected in pursuance to the advertisement dated 10/12/2021. Also, accordingly, the cancellation of such appointment effected in respect of the petitioners here in the considered view of this court would not mandate any interference. The acceptance of the appointments, full stop. This court in the event directs for continuance of the services of the petitioners herein in terms of their initial order of appointment, that would amount to a relaxation being given by this court to the educational qualifications required to be possessed by a candidate for appointment against the posts involved. The said relaxation, if granted, would cause prejudice to similarly situated persons who, noticing the nature of the qualifications spelled out for the post of dental technician, dresser, and dietitian in the advertisement dated 10/12/2021 had not submitted their respective candidatures. Accordingly, no relaxation would be mandated to be extended to the petitioners only in view of their selection and appointment against the posts in question without they fulfilling the eligibility criteria spelled out for the same. So, having drawn the above conclusions, this court would now consider the submission made by Mr. B. Sinha, learned counsel appearing for the petitioner, that the order dated 7/8/2023, 29/8/2023 was issued by the respondent authority, was issued by the Director of Medical Education, Assam, cancelling the appointment effected in respect of the petitioners herein without affording to them an opportunity of hearing in the matter. Also, the facts as noticed herein above would result in the this court has considered the said submission of the learned counsel for the petitioner. Also, however, the said submission would not mandate an acceptance inasmuch as on the basis of the admitted and so on the ground that the admitted and indisputable facts noticed herein above would only lead to one conclusion, that is the ineligibility of the petitioners herein to be considered for the posts of dietitian, dresser, dental technician, dresser, dietitian in pursuance to the advertisement dated 10/12/2022. Also, in other words, even if a direction is issued by this court upon the respondent authorities to hold a proceeding, to conduct a due proceeding against the petitioners before terminating their respective service, this court, as noticed above, view of the conclusion, in view of the undisputable facts existing in the matter, no different conclusion can be arrived at than the conclusion arrived at by the Director of Medical Education, Assam, in the order dated 29/8/2023. In view of the above, this court would draw strength for the above conclusion reached from the decision of the Honorable Supreme Court in the case of Aligarh Muslim University versus Mansoor Ali Khan, reported in 2000 7 SSC 529. Wherein the Honorable Supreme Court had opined that if upon admitted or indisputable facts only one conclusion was, then in such a case, the breach of natural justice was in itself prejudice would not apply. Also, the Honorable Supreme Court in this such decision also laid down that the useless formality of a theory is an exception to the principle of odi alteram partem. Also, in view of the above discussion, next, For discussion, this court is of the considered view that the order dated 29/8/2023 issued by the Director of Medical Education Assam being based on the having rectified illegality committed in appointing the petitioners herein, who admittedly do not possess the requisite qualification for being recruited against the post of dental technician, dresser, dietitian, no error has been found by this court in issuance of the in cancellation of their appointment letters issued to the petitioner earlier. So accordingly, this court of the considered view that the present petition void of any merit, and accordingly the same stands dismissed. However, there would be no orders to cause. Sorry, can't help it.